Morning, my name is Ed David. On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced. Now, we have additional agendas, including the consent agenda, available in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and they will not be considered further today. Remaining cases on the agenda are coming before the commission to determine if reasonable ground exists to believe that unlawful confinement occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one: relevant factual errors, relevant omissions from the report of facts submitted during the investigation, relevant issues and questions concerning interpretation of law. Commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. I'll ask each of you to introduce yourself as you come to the podium. Thank you. We will proceed with the business meeting.
Great. So the first order of business is need a motion to adopt the agenda and the consent agenda. Okay. Is there any discussion? Okay. Seeing none, the commission's remote participation policy requires that I ask commissioners to indicate their vote both visually and audibly. So if you are in agreement with the motion, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
And next, I need a motion to adopt the minutes from the January 2025 commission meeting.
So moved. Second.
Moved and seconded. Any discussion? Seeing none, if you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
I have to recuse myself. I'm absent.
Right. Glad you're feeling.
Oh, 100%.
There has been some stuff going around. Okay. It's a quarterly meeting, so I have many reports for you. First, there is no change in personnel. You to chug along, it's great. Status of our pending cases. So you have a case summary report. We had, oh no, sorry, I skipped a step. Compliance, our conciliation. So you have a conciliation memo from Jane. We have 8 cases in active conciliation. You'll see 4 of those, we're just waiting for signatures or response from the other party on an agreement that's already been reached tentatively.
No question about conciliation. Who does that? Is that staff or is that
Jane? Well, so Jane represents the commission and our mediators to the sort of negotiation.
RJ?
Or Jane.
Yeah,
Yep.
right.
Yep. Because in compliance as opposed to in mediation and in conciliation as opposed to mediation, the commission is a party. So Jane represents.
Yeah.
In mediation, which happens before investigation, the commission is not a party to those agreements. Those are between the parties. And the same mediators do both mediation and conciliation. But in conciliation, which happens after you all have voted on the case, the commission is then a party. And so we are also asking for remedies, like interest remedies mostly. And Jane represents us in conciliation.
And represents us to either that same mediator is serving as a conciliator or somebody else that's hired to do that.
No, it's the same mediators. Yeah,
Same,
so we
it's
have
always the same.
always the same. Yeah, we have a contract with 6 mediators right now. And actually, when we get to new business, I will talk to you more about that program. But we have 6 mediators who are performing mediation for us. They're great. Okay, so 2 unsuccessful conciliations, no successful conciliations at this point, but I do need a motion to accept the agreement in Wanklo versus Pullen et al. H240110 AB. And to let me sign on your behalf.
So I'll move to accept the conciliation agreement in H240110 A, B, and C, the Wonka versus Pullen et al.
Second.
That and appears to satisfy our requirements.
Moved and seconded. Any discussion? Any further discussions? Seeing none, if you're in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
For investigation, we had 42 new charges. In January, with a total of 60 new respondents. 32 administrative dismissals. We had 7 administrative dismissal letters sent for reasons of lack of jurisdiction or failure to cooperate. 9 right to sue letter requests and 13 withdrawals with benefits. So that's 6 that settled through the MHRC mediation program and 7 private settlements. 3 withdrawals with no benefits, a total of about 310,000 to complainants. Yep. And our quarterly reports. Pending inventory, we have about 794 cases pending at the commission with average charge age of 359 days, so just a little bit under a year. We're still on track with that. You have a memo regarding all of the training and outreach that we did in the second quarter of 2025. You have a finance report from Michael, and I will be happy to pass questions on that to Michael. Any questions on any of those numbers that I just flung at you?
Very
Sure.
First of all, I really like that I didn't get into it as much as I had hoped to, depending on previous charges. I think that's very interesting, but one little thing, what is average staff age? What's that about?
I think that
Hope
means
it's slow.
days, we're all infants. I believe that is, so this is the problem with this thing that I pulled, you'll see the EEOC logo up in the top left-hand corner. So this comes from the EEOC database that we are still nominally using to track cases because they still track some things that we haven't been able to build into our own system yet. The average staff age, I think, is the length of time that the EEOC thinks a case has been with a staff person, has been assigned to a staff person. The problem with the EEOC database is that it basically only recognizes the front office staff as staff because they are the only people who go into their database and like open inquiries and log stuff. So you can ignore the average staff age because that actually doesn't have anything to do with how long a case has been with an investigator. Any other questions about any of that? I'd ask that we take litigation in executive session. New business. So you all have, because I forgot to email them to you last week, I will email them to you today so that Commissioner Sanders has them as well. You all have 3, the testimony for the commission for 3 bills, LD 10, LD 141, and LD 152. LD 10 is a bill to add political affiliation as a protected class. This has been brought up before. We testify neither for nor against. We don't have a position on adding that as a protected class per se. We do feel that the number of cases we might get under that protected class would be enormous. And so we have asked for, if the bill gets out of work session as an ought to pass and goes to appropriations, we would be asking for 1 more full-time staff member to help us handle that.
Sorry, what do we be adding as a class? What is
Protected political affiliation.
political affiliation?
Right. And it's a bit broader. There are a couple of states that do protect political affiliation. I think New York and California. And I haven't looked at those statutes yet. I think we'll be bringing that to the work session to see how that's defined. In this bill, it's very broad, and the sponsor of the bill states that yes, this is very broad. It covers basically any political ideology, not just enrollment in a political class, a political party. So we had a lot of very uncomfortable conversations at the public hearing about what those political ideologies might be and what an employer's responsibility would be and other things like that. I won't get into all of that now, but I believe the public hearing is archived if you'd like to listen to it.
It would be so messy, I would think.
It would be very messy. Yes, it would be, it would require us to do a lot of very, I think, intensive investigation into, is this a political belief?
Right.
What about, cases where somebody says something?
Yeah.
So
Right.
You can do it well.
It would be very challenging. And I will say that this bill has not, as written, this bill has been proposed as written before and has not passed. I think you would need to significantly narrow the definition of what political affiliation means in order for us to be able to meaningfully investigate those cases. And you'd have cases where you'd have two different employees filing complaints against their employer, or one person says something because they believe in a terrible political ideology to somebody else who is then impacted by that. Say somebody says something very anti-Semitic, then you have two employees filing complaints against the same employer, and we're investigating them, and that gets messy, and I don't think the employers would like it either. So it's possible that will get significantly, more narrowly defined at the work session, or that there might be amendments, and I will keep you all updated as that goes. But right now, it would be very burdensome. LD, I'm going to take LD 141 last. LD 152 would require us to respond to all FOA requests in 30 days. Like, we would have to produce all the documents within 30 days. So we've added another investigator position to that as well, but there were many other agencies testifying that this would just be impossible. We could do it if we had a staff person almost all the time. We don't have a full-time staff person to respond to those requests, so that's why we were in another corner, and it's just, we would need somebody else to help us do that. 141 is the bill to give our mediators limited immunity for the purposes, we would basically consider them state employees when they're conducting mediations and conciliations. This became an issue, I think I may have spoken to you about this prior. This became an issue when we were renegotiating their contracts, that suddenly their malpractice insurance carriers were saying, oh, well, if you have to indemnify the state for stuff that you're doing during mediation, their rates were going up. One of our mediators, Maria Fox, who testified at the public hearing, has had to step back from doing mediations because her new firm's insurance company won't cover it at all. So we're down a mediator. One of our other mediators recently had to step back, so we will be trying to figure out how to fill that spot if we can. It doesn't cost anything really. It costs us about $1,200 per year for 7 mediators, which we can just absorb in the budget. So we're not asking for money. We just want them considered employees under the Tort Claims Act, like the DOE mediators, the cadres mediators, the Maine Labor Relations Board mediators. Yeah.
Mediators, of which I am one of them.
So I will let you all know probably we will have had the work session by the next meeting. I imagine I'll keep you all updated. But that's our new business. Any questions about any of that? Anything you would like me to bring back at the next meeting? We will be testifying tomorrow at appropriations for a $25,000 supplemental budget request that we've made. Basically, when our previous director of operations left, we then didn't have anybody in that position for almost 2 years. And we didn't have anybody who really knew how the bills got paid, because we hadn't built any sort of redundancy into that system. We had one person who did everything and nobody else knew how to do it. So we are behind about $25,000 because we carried over that year to year, which I think is not uncommon for a state agency. And I also think this is not the year to be asking for that, but we had already submitted it before the governor's budget proposal came out. And so we're gonna go up there and say, listen, we understand this is a tight year and there's a budget shortfall, but we're trying to be fiscally responsible. We'd like to get these bills just paid so we aren't carrying this balance over. So we'll see how that goes. I will send you all the testimony when I have it written today or tomorrow morning.
Okay. So we are on time. Thank you. And the first case on the agenda for cases, I meant to ask, Commissioner Sanders is not with us.
Commissioner Sanders is not with us. No, she's absent today. Sorry.
First case is Robert Witt versus Mount Blue Drug. And as I recall, it is a recommendation for finding that there are reasonable grounds. Jurisdictional.
Yeah, actually, yeah, what happened is that we tabled it for the jurisdictional question.
So do we, is there going to be a vote on that?
I think, okay, let me lay it out. So at the last meeting, respondent had argued that because the report was not, because the investigation was not concluded within 2 years, we lost jurisdiction. And no one had argued that before. So I took a look, I did a bunch of research, and in the end, I have concluded that respondent is correct. The language is the same. The language says that we must complete our investigation with 2 years, and we've interpreted similar language, most notably the language that says that complainants must file their complaint with the commission within 300 days to be jurisdictional. So if a complainant files on day 301, we don't consider ourselves to have jurisdiction. And I think the same has to go both ways. I mean, they're right next to each other in the statute. Clearly, these must was for a reason, and there's no case law anywhere to tell me otherwise. So I think we lost jurisdiction. Given the procedural posture of the case, where it's already been argued and is in front of you, our rules only give you a few options. Those are reasonable grounds, no reasonable grounds, or to send back for further investigation. So I suggest that we get a motion and a second, assuming you believe me, and I'll answer whatever question you have. Assuming you follow my advice, I would have you move to send back for further investigations with instructions to administratively dismiss the case for lack of jurisdiction. Because that is the procedural fix I've found.
I was following you till that very much. Now,
And I am recused from this case.
so I move that we take Commission Counsel's advice and that we send this case back for further investigation with instructions to dismiss lack of jurisdiction. Second.
All right, it's been moved and seconded. Discussion.
Thanks, Barbara.
I hate this. This won't be happening.
Thanks for
Yeah.
sussing it over.
You're welcome.
Okay, so I just want to make sure that I understand this. The motion is to send the case back for investigation with a recommendation to be dismissed.
With instructions to
Instructions.
you to administratively dismiss, since you're the only one who can do it. This was the hardest part, was figuring out how to get it back.
I think the hardest part is the part where human error on our part has impacted somebody else's life in this way, which will not be happening again. I thought we had systems built in. We do have systems built in to prevent this from happening. Clearly, they were not strong enough. So now we have more. I run a report every month now, checking the statutes of limitations of all of the cases that we have at the commission. Prior, we have been relying on the investigators and sort of an informal monitoring of this, and some things get flagged in our internal system, but clearly that's not sufficient. I apologize. I don't think that Mr. Witt is here, but I apologize. Is he?
Yeah.
Oh, Mr. Witt, there you are. I'm so sorry. You're right in the front row and I missed you.
I missed
I'm
you
very
too. I'm
sorry.
sorry.
I'm very sorry that this happened. This was human error. There was no bad intention on our part, but it has an impact on your life, and for that, I want to acknowledge that, and I want to apologize on behalf of the commission that this has happened. And I don't know if it's any comfort to you, but it will not be happening going forward. And I can't comment any further on that, but we take this very seriously. Okay, so we have a motion, a second. If you vote yes, you are in agreement. Commissioner David.
I'm not voting on that.
Oh, sorry, you're recused. Commissioner O'Brien. Commissioner Walker,
Yes.
Commissioner Douglas. So the parties, Attorney Strader and Mr. Witt, you will hear from the commission probably in the next few weeks about this case.
Thank you.
All right, the next case on the agenda is E22-0379 A, B, and C, McClendon versus Walmart. And the recommendation is for finding of no reasonable grounds on either count, discrimination and retaliation. Therefore, we would hear from the complainant.
I believe we're looking for Attorney Beard or Attorney Schmitz. Yes, and that, yeah. Don't have anything. I know they know it's on because I have received their permission of disagreement. Is there anybody here for Ms. London? I see Attorney Thierry. You're here for Walmart.
Yes, I'm here for Walmart and Mr. Collins.
And have you haven't by any chance heard anything from Attorney Beard or Attorney Schmitz, have you?
Let me check my email. No, I have not.
Well, when the complainant is not present and the recommendation is for no reasonable grounds, we generally adopt the findings of the investigator.
All move that we find that there are no reasonable grounds. We believe that unlawful discrimination occurred, and that there are no reasonable grounds to believe it was retaliation.
Been moved and seconded. Any discussion? Seeing none, the motion is to find no reasonable grounds on both recommended findings. If you are in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
The findings are no reasonable grounds. We appreciate everyone's participation. Just want to make sure that they got, this is weird because they made their submission disagreement. Just want to make sure that they got it.
So,
Yeah, they got the notice. Okay. The findings are no reasonable grounds. Attorney Thierry and Investigator Leva, thank you for being here. The commission will send a letter to the parties confirming the results of the hearing.
third case for hearing is E23-0021 A and B, Damon versus Hometown Shellfish. And it is a recommendation for a finding of no reasonable grounds. Therefore, we would hear from complainant.
Attorney Payson, are you here for complainant?
Yes, hello, commissioners. I am here for the complainant, Miss Damon. I was just on the phone with her trying to figure out the Zoom link. She's having some technical problems. Is it at all possible to wait a few minutes just to see if she can get that Zoom up and working?
The commissioners agree we can move on to the next
Well,
case.
we can pass it.
Okay, thank you so much.
Attorney Schmitz,
Yes,
you have missed your case.
we were up second. Is
The first case was just a procedural issue.
apologize.
Is Attorney Terry still on the call? No. For Rachel? Yeah. Sorry. Why we recommend that you get here at 8:45 when the meeting starts. All right, so while we attempt to do that,
We'll do the fourth case.
yes, Beryl was the same charge.
So the fourth case for hearing is ED 23-0151 Beryl versus St. George Municipal School District. And the recommendation is for a finding of reasonable grounds on one count, and therefore we would hear from the respondent.
Good morning.
Morning.
My name
Okay.
changed from Melissa Huey to Michael Busher. So
I noticed that. All right, so Attorney Busher, you have 10 minutes. Would you like to reserve any of your time?
I'll reserve 2 minutes, and I have my own timer here. I don't think I'll need all of it.
Okay, great. Whenever you're ready, go ahead.
Good morning, commissioners. As I mentioned, my name's Michael Busher. I am a school lawyer at Drummond Woodsum, and I spend a majority of my time working with schools around the state of Maine to make sure that all students have equal access to public education. That's a passion of mine, and I appreciate all the work that you all do in furthering those efforts. But I'm here today because I represent the school department, and we disagree with the investigator's report and recommendation. You have our written objection, which cites case law that supports that, so I won't go through that today. But I want to highlight for you several concerns that I have based both in the legal recommendation from the investigator's report as well as the facts. So, that being said, I read this report, and quite frankly, I was baffled because when I look at the facts that the investigator found, the first thing I note is that the student was not treated any differently because of new pronouns, right? And this case is really about whether or not the Maine Human Rights Act and this commission can compel a school to deliver education to other students. And that, just so you know, would be the first time that I'm aware that the commission has ever done that. And it would also potentially be contrary to Maine law. So I would urge you to be very thoughtful. I understand that we are working right now in very uncertain times. It makes my job incredibly difficult. but there are a couple things that you need to know. First, in this case, there simply was no discrimination. The Maine Human Rights Act protects students. It protects people. It doesn't protect books. And when you look at the facts of this case, it's really clear that the student here was not treated any differently because of gender identity. In fact, the student, everybody agrees, was supported, was well received. The student was allowed to share her new pronouns with her first grade class. And the student was given the same opportunities as other students. One of the things that was discussed at the Issues and Resolution Conference is that this student was given the opportunity to bring a book of her choice to school. And you know what that student brought to school? I love this. Paw Patrol, right? Because we're talking about a kid, right? And while there were some bumps in the road where some of the first grade classmates did use incorrect pronouns, the teacher diligently helped them to understand, right? So the last piece is that everybody agrees that there was actually no adverse impact on this student, right? The school does, the teacher does, mom does. So I'm really baffled because if you think about what the standard is, right? The standard is that here, complainant had to show that the student was a member of a protected class, right? Which they did. And the school department said, the only reason that we're not going to read your requested book, Mom, is because we already have a working group that is looking at this exact issue. And this is a really, I mean, as everybody knows, we're all watching national news. This is a hot button issue. So we want to be really thoughtful about how we deliver education around this issue to elementary school kids. And that's exactly what the school did. Now, the investigator in her analysis gets the standard correct, but the application goes sideways, right? And what do I mean by that? The report acknowledges that the school did offer a legitimate non-discriminatory reason, right? Because the school was trying to figure out how best to deliver this education. But where things went sideways is that the investigator seemed to conclude that even though the school offered a non-discriminatory reason, right? And this is in that paragraph 7, I believe, of the findings. This is on your last page of the report, right? The report confusingly says that no, actually respondent failed to articulate a legitimate non-discriminatory reason. And then interestingly, if you look further down, school's desire to approach its curriculum choices deliberately may be non-discriminatory, right? And even that it's assumed that the school provided a legitimate non-discriminatory reason. But then in paragraph 8, right, you look at that last sentence, all of a sudden, even though the school offered that reason and the parent did not rebut that reason in any way, shape, or form, right? Somehow the totality of the circumstances show that the school discriminated against the student. And interestingly, based on the child's gender identity and the book's content in relation to it. So here's the thing. Schools absolutely have the ability to determine what educational materials are delivered to kids. And in this case, you have a parent requesting that a specific book be read to a class. And you have the school making a thoughtful decision about whether that's the right book to be read to the class, right? There is no evidence in this record that supports a finding of discrimination on the basis of a gender identity. Absolutely, the book in question was about pronouns. But the Maine Human Rights Act doesn't protect books. Look, I have schools around the state that are banning books, right? And that is not discrimination against kids, right? May not be a good choice, but that is not what the Maine Human Rights Act protects. The next piece that I'll point out for you is that the investigator, the report, also seems to say that there was public accommodation discrimination. But I want to be really clear. If you look at the case that we cited, the most recent Portland case dealing with Portland's taxi regulations, right? Public accommodations have to do with spaces, right? Public accommodations have to do with access to that space, not curriculum, okay? And there's no Maine case that says curriculum is an accommodation. Lastly, I just want to point out, and you've got the statutory references, but under Maine statutes, school boards have the authority to decide curriculum and to decide educational materials. 20A MRSA 1001, right? It's right there. You should not accept the invitation to substitute your judgment for that of a school board, okay? No court can do that, and the Supreme Court has said that no parent or student can do that either.
Those are your 8.
Okay, thank you.
Questions for Attorney Busher? Commissioner Douglas?
Yes. Morning.
Good morning.
Or up late watching Super Bowl like I was. Yeah.
Only half of it, so.
Yeah, I think only Eagles fans watch the whole thing. So, I'm wondering, all this seemed to have come to a head in March of 2023, right?
Correct.
The way I read this record, school is saying, we need to sort of take this under advisement, right? Let's not do it now, but we need to have some more conversation with our working group to figure out what we're gonna do about this. I'm wondering, is there anything in the record indicating what decision they came out to? Like, did they say ultimately it was good or it wasn't good, or I see the investigator nodding no, but was there any determination as to whether or not this actually would be appropriate?
So
If it's in the record.
So in the record, there's no determination because that happened later on. There is, however, in the record, an indication that later that spring, the school civil rights team, with the support of the social worker who was involved in this issue, chose a different book about pronouns. And middle schoolers actually read that book to the first grade class.
And then what's your take about, I mean, I'm looking at this paragraph 8 you referred us to, and it says, I'm just gonna read it. It says that the IRC teacher confirmed that books about other protected classes are read at school, that books are chosen by teachers without oversight. I mean, because that's sort of the basis for the finding here, I think a fairly important basis. What's the distinction between that and this case, right? Reading books about other protected classes versus,
right,
all the hullabaloo about this particular book being read.
Sure. So I think there's a couple things. First off, don't lose track of the fact that the superintendent said, right, and the investigator said that his statement was credible, that he wasn't aware of a parent, right, selecting a book and having that book read in the last 8 or 9 years. And I think that's the distinction here, right? I mean, look, we have parents who request that things be read all the time. I don't want to make the classic lawyer slippery slope argument, but I'll make it, right? If you say here that the Maine Human Rights Act requires the school to read this book to a class, right? That's a two-way street. It's not just books that are current, right? I mean, you've got a pending bill talking about political affiliation. Don't lose track of what's going on, right? But ultimately, it's really important that that distinction be clear. And look, I know that mom is a teacher, right? Mom's a great teacher. So, but mom in this case is mom. And if you look at the record, it's not the student that was asking for this book, right? Mom suggested this book. And that is not how we ultimately choose which books to read. Of course, there are books about protected status that are read, right? We're in the middle of Black History Month. So if you adopt this investigator's report, what you're saying is anytime a parent of a child who's a member of a protected class, so let's take, for example, You have a child who is of Irish descent, so national origin, right? And the parent wants the classroom teacher to read a book to kids about the Irish immigration into this country, right? Under this standard, the school would have to read that book. And I don't think that's what the Maine Human Rights Act intended. Like I said.
I think you made your point. Yeah.
All right.
Yeah. Thank you.
Commissioner David.
Attorney Boucher, it seems to me that you're trying to get us to, you're making the argument that for us to find that there's discrimination in this case on these facts means that we're mandating the reading of a book or that we're changing curriculum. And that's not the facts of this case. The facts of this case are that principal, a social worker, and a teacher met with mom as part of a student, as part of an indication of a student's health progress in transitioning, and that they agreed that this was an appropriate thing. And then it's the superintendent that overrules them. And it seems to me that the facts of the case are not, you're trying to get us to conflate or believe that we're mandating a curriculum change. And I don't think we are. I think we're the facts of a specific case.
I would respectfully disagree that those are the facts here. In fact, at the Issues and Resolution Conference, the principal specifically said that he did not promise that that book would be read. In addition, right, when you think about what's here and you look at those facts, right, and I'm just encouraging you, look at them on their face. I can disagree with the rest of it. But as this report is written, if you apply the legal standard that you must under the Maine Human Rights Act, right, these facts do not support a finding of discrimination. Nothing in this record indicates that the student was treated differently because of the student's gender identity. Instead, what the record shows is that the school made a determination to not read a book about pronouns, right? That has nothing to do with this student. If the parent of a cisgendered student had requested this exact same book, the school's response would have been exactly the same.
Other questions for Attorney Busher? Seeing none, Attorney Busher, you'll have 2 minutes when we come back to you.
Thank you.
Ms. Verrill, you have 10 minutes. Do you want to reserve any of your time?
Yes, sure. I don't think I'll need more than 5 minutes.
Whenever you're ready, go ahead.
Sorry, I'm just going to read something. Thank you for letting me speak this morning. I do want to start with the fact that I don't agree that there was no impact for my child. She was misgendered for 3 months. That's always going to have an impact on a child. But I'm just going to kind of summarize everything and try to address as I go through the timeline. So in March of 2023, my child started using she, her pronouns. She was only in 1st grade. So my husband and I met with the school social workers, the school principal, and my child's teacher in order to discuss how to make this transition. As part of the plan, we decided the book, What Are Your Words? A book about pronouns would help support my child and her classmates in this transition. Much has been made about this book being a parent recommendation. And while I am a parent and I did recommend it as a parent, I'm also a teacher. And the book was accepted by a team of professionals who agreed it would be a helpful way to support my child and frankly, her class to understand what was going on. The next day, I was informed the book could not be read to my child's class. Mr. Felton, the superintendent, said he wanted the school culture working group to review the book and discuss how to teach gender identity at the elementary school level. As a teacher at the school, I was part of the working group Mr. Felton mentioned. And in the last 3 months.
Ms. Verrill, I apologize. I didn't say this at the beginning of the meeting. The commission's confidentiality provisions require that we not use the name of anybody who's not named as a party. So you can use the name of the school, but otherwise just use people's titles, please.
Okay, sorry about that.
That's okay.
So as a teacher at the school, I was part of the working group. And in the last 3 months of school after this incident, the working group did not talk about books or curriculum. Another talking point for St. George is that books are part of the curriculum and the school board has final say in whether or not they are read in classrooms. They've even gone so far to say that the school board withdrew teachers' rights to select books on gender identity. St. George MSU School Board Policy IJJ defines instructional materials as textbooks and other print materials, software and other electronic materials, online/internet resources, including access and supplies and other materials to support instruction in subject areas and implementation of the system of learning results. This book was not intended to support instruction, it was intended to support a person. This supports the investigator's finding that the request to read a book was not a request to change curriculum, but a one-time support for a difficult conversation in transition. If it was truly St. George MSU's intention to be mindful in their instruction and support of learning about gender identity in the classrooms, they had 3 months to do so. Even with a gender nonconforming student in the first grade classroom, they did not discuss books or any form of supports in the working group. The book that was mentioned by the lawyer was actually read to the kindergarten classroom and not the first grade classroom. The district claims to have provided all the necessary support to accommodate my child because she was allowed the time to express her change in pronouns. All the adults in the school used the correct pronouns and her teacher modeled the use of correct pronouns. The district also mentioned she was able to bring in a book of her choosing, but that happened in January, actually after another incident where she brought in a book that was not allowed to be read. It was not in response to my child's pronouns. And yes, she did bring in Paw Patrol because she was 6. In reality, beyond these 3 basic accommodations, the district provided no additional support despite only one of her classmates using the correct pronouns. The social workers did not check in with my child or her teachers, and the district did not provide support or education to prevent the misgendering of my child in the remaining 3 months of school. Thank you for your time and effort in this case, and I appreciate the work being done by the Maine Human Rights Commission.
Thank you, Ms. Verrill. Any commissioner questions for complainant? Commissioner Douglas?
Yes, good morning.
Good morning.
Thank you for being here to advocate for your child. I appreciate that. You referenced a book, the same book was read to a kindergarten class. I'm just wondering if it's in the record in this case, when was that?
It was a different book that was read to the kindergarten class, and it is not in the record in this case.
Okay.
Other commissioner questions for Ms. Verrill?
You know, as far as you know, it's not in the record whether the study group has made any recommendation
It is
on this topic of teaching, you know, about gender identity.
the minutes from the working group are in the record from from January till the end of the school year in June, and there was no recommendation during that time period.
What we're talking about happened in March.
Yes,
So from March to June, there is nothing, the minutes are there and there's no indication that the study group took up the issue.
right. And I brought up the book once, and one of my colleagues brought up the book once. Both of those are in the minutes, but it was not addressed.
Am I hearing, maybe it's my feeling, I'm not sure if it's yours or not, that the statement that they couldn't, the superintendent's statement that you can't read the book now because the study group's working on it, and then the lack of any address by the study group is an indication that it was a pretext. That they were
Yes.
just waiting. Okay. Thank you.
Any other questions from Ms. Verrill?
Oh, yeah, I'm sorry. Who was involved in your initial conversation and agreement to have the book read that was then overruled?
2 social workers, my child's teacher, and the principal.
And all of you agreed that it would be appropriate to read the book and that the book would be read?
Yes, and my husband was there too. And yes, we all agreed. And I did submit the text I sent my husband after I was told we were not going to be able to read the book.
Are you a teacher in that school? guess
I was. I am not anymore.
Thank you.
Any other questions for complainant? Seeing none, you'll have about 6 minutes when we come back to you. Attorney Busher, you have 2 minutes.
Thank you. I will leave you with this. You are being presented with what is ultimately would be an issue of first impression. And I understand that we are currently in very uncertain times. But I would urge you to look at the facts of this case. And quite frankly, what complainant shared with you, a bunch of that is not in this record. But here's what is. The student was supported. There was no adverse impact, right? And ultimately, you have a parent requesting that a book be read. Anytime a teacher is addressing a class, that is delivering education, right? The Supreme Court has actually limited the First Amendment rights of teachers to some degree, because when they're in a class, they're speaking on behalf of the board. So it strains credibility to say this was a one-time decision, right? It's not an accommodation to deliver education to kids. There's no case that supports that. I appreciate that this is a difficult case involving a hot button issue, but it is not the case that you are looking for.
Any commissioner questions for Attorney Busher?
Yes, just to follow up on our conversation before, what does the record reflect in terms of why there was apparently no follow-up, no decision on this issue? I mean, is there a reason, is there a justification as to why this issue is presented? We say we're presenting it to a working group and then there's no, there's no decision, there's no follow-up. Is there anything in the record about that?
I'm not aware. So complainant is correct that the working group continued to do work. They did bring it up. And again, this issue was addressed, but that's not in the record. So I don't want to speak to that. Instead, I would just encourage you to look at everything that is. And when you look at the standard, right, the Maine Human Rights Act is about people and about kids. It's not about the content of books.
Questions for Attorney Busher? Seeing none, thank you, Attorney Busher. Ms. Beryl, you have 6 minutes left if there's anything you'd like to add.
I just would like to add that I agree this is about people and this is about support for my child that was not provided. And as a result, she was impacted. Her education was impacted. And we even switched schools so that she would be at a school that would be supportive of her pronouns. And the new school has been wonderful. And that has been beneficial for her. But it was a big deal to have to switch. So that was also a negative impact.
Any other commissioner questions for Ms. Beryl? None. We've heard from the parties, and next we will hear from Nooper Leva, the investigator assigned to this case.
Good morning, commissioners. For me, this case was simply about a child having a book that they requested read. I understand that the mom may have requested this, but again, we were speaking about a first grader who was 6. So when the book was recommended that it be shared with the class, to me, it felt less like a curriculum issue as like the whole grade was being taught the issue. It was just her class that this book was going to be read to, just to help the students understand better the transition that she was going to have and why, maybe not why she was transitioning, but like the better understand how her pronouns were changing and the effects that it would have on her. And because it was only about the class and not the entire grade, I did find that there were reasonable grounds that there was discrimination.
Commissioner question, yeah, Commissioner O'Brien.
Good morning. I've really been struggling with this one. And I'm not sure if parenting issues have anything to do with this in the respect of it is, comment on this, please. It is parents have a right to educate make their parenting choices and have their child educated the way, how they choose. What about the fact of other first graders' parents? Do they have the right to parent and bring up these very sensitive issues at that age? Does that have anything to do with any of this?
So there was no information about that in the record, and that was not anything that I had considered making my decision.
And I'm having a hard time saying why not is it that part of the decision. I guess let me just mull it.
Any other commissioner questions for the investigator, Commissioner Douglas?
Yeah, good morning. Morning. There's been some commentary here, particularly about a complaint about how there was no support for the child, particularly after she sort of revealed the gender issue to the class. And I'm wondering, is that reflected in the record? These allegations about there being no support or lack of support for the child?
All that was in the record, and what Ms. Farrell said, the child did have, the teacher did model correct pronunciation and correct pronouns. The kids did struggle, but again, they were first graders, so that didn't seem entirely out of the realm of possibility. And so I do think that based on the information that I did have in the record, there was the support that the school could provide in this particular case, and that's what I was given.
Yeah. All right. So just to be a little more specific, other than the misgendering, right, which is covered, I think here, was there any other evidence in your investigation that the student wasn't supported by the school?
No.
And then, it seems like March 10 is when all this goes down, right? There's all these things happening. This one's meeting with that one. The child makes their announcement and all these sorts of things. There is, I believe also on March 10, yes, superintendent meets with teacher to ask about how we're going to approach this issue. And teacher says the child shared her new pronouns and that this change did not lead to any harassing, bullying, or ostracization. And I'm wondering, I struggle with that word, and I'm wondering, did you get the sense that the school considered the issue with respect to that particular child closed at that?
To me, what was given to me in the record was that the school made the issue based on a curriculum and what they were wanting to teach and how they wanted to approach this issue with the entire first grade class and not this particular student and the particular transition that the student was going to be experiencing with their change in pronouns.
In your subparagraph D here, it says that there's a reference to March 10 and the revealing of the new pronouns. And then it says, child was not harassed or bullied, left out of educational social interactions, or negatively affected educationally or socially due to her new pronouns. And I know there's more, but I'm just wondering how far into the future, if at all, does that go? I mean, that
only went through the end of the school year. That was all that was included in the record as far as how long that went.
Thank you.
Any other commissioner questions for the investigator? None. Thank you, Newber. We've heard from the parties and the investigator. At this time, we're looking for a motion. There is one proposed finding.
that there are reasonable, that we find that there are reasonable grounds to believe that the respondent discriminated on the basis of sexual orientation or gender identity, and conciliation be attempted. That there are reasonable grounds. Fail for the lack of a second.
Do I have a second? Who else want to make a motion? Commissioner Bryant.
I would move that there are no reasonable grounds. And it should be dismissed.
Second.
And moved and seconded. Any discussion? Commissioner Davis.
I just want to say that I struggled with this case a lot. Is a hot button issue. I was almost persuaded by the respondent's argument that that's trying to get us to generalize a decision if we found that there was reasonable grounds, that we're establishing curriculum or that we're making some educational decision or that it has some precedential value. And as I reread it, I don't think it was. I think this is an individual child with a treatment plan that came to the teacher, and I suspect an avoidance of that hot button issue by saying, "Oh no, we have a study commission, we can't do that," and being overruled by the superintendent. So I'm going to vote against the motion on that basis.
Ryan?
I don't know who was there. You just said part of the transition plan. Was there a plan? I mean, like an IEP, was there a plan? I think that.
Not in the school, but with the parent and explaining it to the principal and the teacher and the two social workers, that group agreed that this was appropriate for this child to make this presentation to the class. And that it was not unprecedented, and it's only this one class and this one kid's peer is not a curriculum change for the whole first grade. And we're being asked by the respondent to say, "Oh, your decision means that you're deciding curriculum." But I reject that. So.
You know, sometimes when I go out to eat, like especially when the menu is really large, right? You look at the menu and like I'll pick out 5 or 6 things that I really like, and then my kids always say, "What are you going to order, Dad?" And I say, "Well, I'm just going to decide when the waiter or the waitress gets here." That's sort of how I feel about this. I'm undecided. I didn't motion or second either motion.
We have not heard
the issue. The issue I'm having with this case is I don't think it's unreasonable for the school to say, when presented with certain material, we want to have a look at this, we want to think about it before we decide. I don't think that in and of itself is discriminatory. Where I have a problem.
I don't either.
Yeah, where I have a problem is where there's no, I mean, I can only imagine this book, I haven't looked at it, maybe it's like 10 pages long.
Right.
And I would think that would be 15 minutes in the superintendent's office looking through the book and saying, this is appropriate, it's not appropriate, when you have a whole phalanx of people that say it's appropriate, right? So I think that a swifter turnaround, I think it's not a legal standard, but I think that would have been more appropriate here, but then I read in the record that the superintendent followed up with the teacher on the same day and said, "Well, I made my announcement and everything seems to be fine." And I get the sense, this is just my sense of it, that the school at that point said, or the superintendent said, "All right, well, we're fine then. We don't need to deal with this book anymore. We'll keep the work going," which I think is also a mistake.
And we're not really studying it either.
Right.
Yeah.
We're not doing anything. So it's hard to imagine a good reason why this book could not have been read. You know what I mean? But I can sort of see it from the school's point of view. And then I think just getting to the bigger issue raised by Attorney Busher here, I think we all need to think about the fact that we may have some other things coming down the pike later. And I think that if those things do come down the pike, I think we're gonna want schools to take a second and have a look at it and say, but not just drop it all together and push it under the carpet, just seems to be what happened here. This issue's dealt with, so we don't need to deal with it anymore. So I'm having a really hard time with this one, if we were judges, so we could take it under advisement, and argue about it, but we're not, so.
I'm glad you, Commissioner Douglas, I'm glad you made those comments because I thought I would be the only one that as I'm listening to Attorney Busher's arguments, he's convinced me. As I listened to this, Mrs. Verrill's argument, she convinced me. So it's like I'm going back and forth as well, and it is a struggle, but I think I'm erring on the side of it is appropriate for the school to look at and determine if it was appropriate curriculum. The big picture, as you're trying to argue. I wish we had, more, like you said, take it under advisement, but.
Further discussion. Seeing none, the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David,
No.
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas. I gave you as much time as I could.
The motion's no reasonable grounds.
Motion's no reasonable grounds.
Ultimately, we vote no.
Okay. So it's a tie vote. When there is a tie vote, the finding reverts to the investigator's finding. So this is a reasonable grounds case. We will send a letter to everybody. We appreciate everyone's participation. The commission will send a letter to the parties and the council confirming the results of hearing.
Can we complain to Commissioner Sanders that she ducked off?
That she, I believe she's at a basketball game. She did let me know that she was gonna be out
yes, I
like
know.
3 months ago. Okay, so we have Attorney Schmitz here for McClendon versus Walmart. Up to you all, I think, whether or not we hear that case. And if we do, Attorney Terry is here. If you decide you would like to hear it, I would just ask for like a 3 minutes.
Also, you'll need to make a motion to reconsider because you'd already voted.
Oh, right.
I'll move to reconsider with a reprimand to the attorney.
Second.
Okay, it's been moved to reconsider the finding in, I don't even have the case number here, but in McClendon.
22-0379.
Moved and seconded. Any discussion? Okay, if you vote yes, you are in agreement. Commissioner David,
Yes,
Commissioner O'Brien.
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
and we'll be in recess for 3 minutes. Meeting to order, and we'll return to the second case on the agenda was E 22-0379 A, B, and C, McClendon versus Walmart. The recommendation is for a finding of no reasonable grounds on both counts, and therefore we will hear from the complainant first.
Good morning, everyone. Apologies again for my tardiness. My name is Ryan Schmitz on behalf of complainant Melody McClendon, on behalf of her now adult child, Katrina Ross.
Can I just pause for a moment and ask, child was a minor while the case was pending. She's now not a minor. Do we care about using her name?
Usually we, instead of it being, I assume Ms. McClendon is mom.
Yes.
Usually, I think what our rules say is that we'll actually substitute the now non-minor child's name because Ms. McClendon no longer has to act on her behalf, but, so no, I have no problem with using
I meant
the
to ask
name.
before the meeting. So, all right, apologies, go ahead.
Okay, so I don't have a ton more to say other than what's in our objection. I mean, we object to a lot of the findings and the characterization of the facts in the report. I think the report either misses or outright denies the existence of facts that are in the record, facts that are material to both our disability, our race discrimination claims, and our retaliation claims. I think, you know, particularly the report's sort of summary dismissal of the disability discrimination claim based on the fact that I believe the report says there are no facts in the record, or the record, nothing in the record suggests that Walmart even knew about her disability. That is demonstrably false from the record. There are emails to Walmart. There's a discussion of the allegations that Ms. McClendon called one of the managers, expressed to them that Ms. Ross has a disability. The manager responded, well, she doesn't look disabled. And so that, you know, our argument is that was a request for reasonable accommodation. That also, I would say that comment, she doesn't look disabled, is in itself discriminatory, denying the existence of an individual's disability in the midst of what was hopefully the interactive process to come to a reasonable accommodation is a violation of the American with Disabilities Act and MHRA. And then, of course, there's also in the record a submitted reasonable accommodation request and acknowledgement from Walmart's accommodation third-party service to Ms. McClendon that shows that they submitted a reasonable accommodation request. So the denial of that in the investigator's report, I think, is problematic and merits the investigator's recommendations being set aside. So I would point to that in terms of the disability claim, the fact that it was sort of summarily dismissed in a footnote, I think is objectionable. I also want to talk very briefly about the race discrimination claim. I would disagree with the investigator report's analysis on what a hostile work environment claim is. I also think the investigator's report completely ignores a disparate treatment claim based on race. I mean, the question for disparate treatment is an individual treated differently based on her race, and I think it's obviously true here. Both Walmart and the investigator's report acknowledges that the N-word was used in front of Ms. Ross, her three siblings who are also people of color, in which of course, as the investigator's report notes, a single use of the N-word could be sufficient to create a severe and pervasive environment, sufficient for a hostile work environment claim. But there are other claims too. And I think the problem with the analysis in the report is that it sort of treats those individual incidents of racism on their own and say, well, this one doesn't rise to the level of hostile work environment. And, you know, calling a Chinese girl Wong doesn't rise to the level of a hostile work environment. Asking if she speaks Chinese and saying the word Wong, the investigator's report doesn't even mention this one, but it's right there in the complaint. Telling a young Black girl that her hair is big and poofy and must keep her warm. That isn't even talked about. And leaving aside whether those three things on their own are sufficient to create a severe and pervasive environment, certainly combined, I mean, that is both severe and pervasive. I mean, these are like, individuals, a person of color's hair is specifically referenced in the Maine Human Rights Act regulations. I mean, these are sort of like well-accepted racist tropes that, my client, Ms. Ross, was continuously experiencing. Those are just the comments. Now, I think we can also talk about the way that she was sort of subjected to being forced to do labor that her white colleagues was not forced to do, something that a recording sent in this record, sent to Walmart. There's a manager saying she should never have been given totes that are higher than her. She should never have done that as a breach of protocol. And again, like that breach of protocol, that different treatment, that's all part of an analysis that goes together with the comments, that goes together with it can't be treated, each individual act can't be treated on its own to establish whether something is severe and pervasive. It needs to be, this is black letter law. It needs to be viewed in unison. A hostile work environment is one claim comprised of many discrete acts. That's the Supreme Court case law says that. And so I think that's where I would object to the legal analysis is that they were sort of treated as their own individual claims versus an entire, a sort of broad spectrum of racist act and discrimination. I think the other sort of big failing in the legal analysis is that there's no discussion of the timing of these events. There's the 11 days after Ms. Ross reports that she experienced this racism and reports that she's being treated differently and being forced to do labor that other white employees aren't being forced to do. She gets injured because she's being forced to do a task that she wasn't supposed to be doing. Again, there's a recording of a white manager admitting that. That's very suspicious timing, something that I would say the courts are most convinced by in terms of analysis and pretext is timing. That's just, it's absent from the report. So, given the, I would say, incomplete legal analysis and the denial of significant material facts, all of which are in the record and available to the commissioners and were available to the investigator, I would say that merits the investigator's report, the recommendation being set aside by these commissioners, and at least a 50-50 chance that there was discrimination and retaliation due to Ms. Ross's race and disability and protected activity.
Yeah, Commissioner Davis.
Aren't 3 people fired for using the hostile?
The individual who said the N-word was fired, but in the record, there was a recording right after the individual said the N-word.
Because 3 people were fired.
My understanding is that only the individual who said the N-word of that scenario was terminated. I can't speak, the names are not, I'm not allowed to use names, but there are other individuals on that recording who are heard laughing at and saying, oh, you've got to be kidding me, and sort of waving away Ms. Ross's concerns about the fact that, this guy, she confronted this guy for saying the N-word, this white coworker. That again is additional evidence of well, why are these people of color being sort of ignored, treated differently, or outright attacked for confronting a coworker who said the N-word? That individual was fired several months later, well after Ms. Ross had already been put on workers' comp leave due to, for sustaining the injury for being assigned a task.
Why doesn't she return after the workers' comp leave?
Was that our argument is that she was constructively discharged, that no reasonable person would go back to an environment like that.
Would go back to an environment.
Right.
And you're laying that environment at the feet of the corporation.
Yes.
And saying that they didn't respond to those comments appropriately in whatever discipline they took to those individuals.
Among other things, I think
or promptly.
I think there are other white coworkers. There's the supervisor who we allege was treating Ms. Ross extremely inappropriately, talking to her in a way that caused Ms. Ross to break down into tears and leave the room, which then prompted Ms. McClendon to call her manager and say, hey, she's got disability, she has trouble communicating. Please, we need to be treating her differently, communicating with her differently, To which that different manager responded, she doesn't look disabled to me. So there's a sort of large spectrum of things that Miss Ross experienced. It's not just this one coworker saying the N-word, which we can see, yes, they did the right thing, eventually terminating him, but it was her white coworkers.
The last question, does the disability not require a formal process and asking for an accommodation?
Well, she complied with that formal process. She submitted an accommodation request to the third party. It's marked in my.
And that was
as an
granted
exhibit.
with the restrictions on what things she had to. Maybe I'm confusing the cases. Was there an accommodation made?
No. Soon after she submitted the formal accommodation request, she was injured. So no, she was never accommodated. In fact, Walmart denies ever receiving an accommodation request, which the report adopts without looking at I'm not sure why, but the report adopts Walmart's.
Adopts that fact that they.
Adopts that Walmart says that we never got, even though the record shows that, like the third party sent an acknowledgement of receipt of the request. It's in my exhibit A. Yes.
Any other commissioner questions for Attorney Schmidt?
I just want to make sure I'm not missing any. So in terms of the disparate treatment claims that you referenced, there's this business in your submission about the pallet being right when white coworkers were not subject to doing stuff like that. The pallet was like bigger than her, something like this, right? So there's an example. Then there's this language that's used, N-word, which 3 people were fired, at least that's what the report says. And then this business about Wong and the Chinese, I'm not sure what happened there in terms of the employees. I'm just wondering, is there anything else?
I mean, between the subjecting her to conditions that resulted in her needing several months to recover from an injury, the use of the N-word by more than just one employee, though one was reported and eventually terminated, the treatment by her supervisor, the fact that her accommodation request was dismissed by the manager saying that she doesn't look disabled. And then the just general ostracization of being a Black and biracial woman with a disability amongst just a sea of white coworkers, many of whom are actively hostile towards her. No reasonable person in her position would return to that work. And then if we're just talking specifically about the disparate treatment claim, I mean, I would say, there were no white coworkers who were subjected to racial slurs. There were no, these white coworkers weren't moving pallets that were bigger than her, despite her saying, "Hey, these are too big. I can't do this anymore." It just is out the report. It's clear that Ms. Ross was being treated differently. It was severe. It was pervasive, but at simplest terms, her working conditions were not the same, and it was because she was a person of color and because she had a disability.
Questions for Attorney Schmidt?
I'm trying to go over the other named respondents, Skylar Ellis and Darren Collins, that the investigative report dismisses as says Skylar didn't do anything, I think. Is the allegation that they participated in those discriminatory in creating that hostile environment?
Yes, I want to keep the focus on Walmart because they are the employer and they were responsible for making sure her conditions were not discriminatory or, let alone hostile. But yes, Skylar was the trainer who was harassing Miss McClendon, harassing Miss Ross, the one whose treatment resulted in Miss Ross leaving the building in tears. She was, standing behind Miss Ross, watching her, telling her that, like she's aggressive towards employees, which in and of itself, I believe is Miss Ross is like a quiet young girl at this point. She's aggressive towards coworkers and customers. She's not even a customer facing job really. I think it's, that in itself is a trope, but I have a limited amount of time, so I didn't want to get too grainy on it. But yes, I would say those named people are also absolutely responsible for the conditions for working on.
Questions for Attorney Schmitz? Okay, seeing none, I'm gonna have about 3.5 minutes when we come back to you.
Thank you.
Attorney Terry, thank you for joining us again. You have 10 minutes. Do you want to reserve any of that time?
Yes, at least 2 minutes.
Okay, whenever you're ready, go ahead.
Sure. My name is Rachel Tierhe, and I represent respondent Walmart Stores East and individual respondent Darren Collins. As a brief recap of Ms. Ross's employment history, Walmart employed her for approximately 11 months. During that 11-month period, Ms. Ross worked around 300 hours, which is the full-time equivalent of 8 weeks. Also during the 11-month period, Ms. Ross took a leave of absence lasting over 7 months and received over $21,000 in workers' compensation benefits from Walmart. While Ms. Ross was employed with Walmart, she was never subject to disciplinary action or any other adverse action. Mr. Darren Collins hired Ms. Ross as a personal shopper. A personal shopper is one that is responsible for receiving online orders placed by Walmart customers who intend to pick up their order later at the store. The personal shopper receives the customer order and then will shop for it and deliver the products to the customer's car when they arrive. An essential job requirement for a personal shopper is the ability to move, lift, and carry up to 50 pounds. When hired, Ms. Ross acknowledged she could perform the duties of her position with or without an accommodation. Approximately 1 month into her employment, Ms. Ross went to Mr. Collins and claimed that Skylar, another personal shopper who was asked to train Ms. Ross, was bullying and telling her what to do. Ms. Ross concluded that the reason for Skylar's behavior must be because of her race, though Ms. Ross could not identify for Mr. Collins any specific behavior or words that would indicate that even if the behavior was true, that Skylar held any animus towards Ms. Ross because of her race. To further investigate, Mr. Collins spoke to Skylar, and Skylar reported that when she attempted to provide Ms. Ross with constructive feedback, Ms. Ross would get offended, express distaste towards Skylar, often ignoring her while she attempted to train. As a result of Mr. Collins' investigation, he could not substantiate any discriminatory conduct or even inappropriate conduct that would violate Walmart policy. Even still, because of Ms. Ross's frustrations, he removed Skylar from her duties of training Ms. Ross. Ms. Ross's mother, seemingly displeased that Skylar remained employed, began a barrage of complaints to Mr. Collins, claiming he was discriminatory and that he was making Ms. Ross work harder than other associates, although this was impossible because of the nature of the automated customer order assignments. In what could be described as an attempt to escalate her frustration over Mr. Collins' handling of the Skylar complaint and force Mr. Collins to take action against Skylar, Ms. McClendon demanded her daughter be treated better because she was disabled. Mr. Collins asked Ms. McClendon to explain, but Ms. McClendon never identified a disability or stated an accommodation that would be needed. Walmart's accommodation policy spells out the specific steps associates should take to request an accommodation. This includes engaging in the interactive process via Walmart's third-party administrator, Sedgwick. As noted in Mr. Collins' position statement submitted to the Commission on February 8, Ms. McClendon called Sedgwick to report, and I quote, that she wanted the store to not put everyone else's assignments on her daughter. I apologize. She also told Sedgwick in that call that she wanted the store to take action against Skylar. Sedgwick acknowledged this call with a letter, which Mr. Schmitz presented as an exhibit. However, it is important to note that the same exhibit advised Ms. McClendon that what she needed to do to request the accommodation, which was to provide medical documentation. She did not do this. According to Sedgwick, Ms. McClendon called them again in February 2023. Sedgwick advised that the matter had been closed because Ms. McClendon had never responded to the request for medical documentation. Ms. McClendon argued with Sedgwick that she had in fact sent the paperwork. So they gave her the benefit of the doubt and they advised her again to send the medical information. However, once again, Ms. McClendon did not send any documentation to Sedgwick. Therefore, an accommodation request was never made. Shortly before going on leave, Miss Ross complained to Mr. Collins that she overheard 3 of her coworkers referencing a racial slur. Unlike the prior complaints about Skylar, this complaint contained specific behavior with implications of race. This was a serious matter. The matter was investigated, and Walmart did, in fact, terminate 3 individuals because of it. On November 2nd, 2022, Miss Ross was pulling a cart that had totes on it. She got it stuck on the door frame. She continued to pull the cart, trying to get it through the door frame, causing the totes to fall forward. According to Ms. Ross's statements written immediately following the incident, the following totes hit her on the right arm and knocked her to the ground. The fall resulted in the inflammation of her shoulder. Due to this inflammation, she remained out of work for the next 7 months. When she returned, she worked 7 days and then resigned. Walmart paid Ms. Ross over $21,000 in workers' compensation benefits while she was on this leave. Based on the above, I want to make 3 critical points. Walmart and Mr. Collins did not discriminate against Ms. Ross because of any alleged disability or because they failed to accommodate her. Even ignoring the fact that Ms. McClendon's statement that her daughter was disabled was an attempt to bolster her complaints against Skylar and the alleged bullying, the truth is that Ms. Ross successfully performed the essential duties of her job and never requested an accommodation. Cedric advised Ms. McClendon the steps necessary to request an accommodation, but she ignored the request, failing to engage in the interactive process. Number 2, Ms. Ross was never subject to any adverse action. She was never issued disciplinary action and never subject to termination. Mr. Collins heard and listened to every complaint that was brought to him. Finally, Ms. Ross has failed to establish a valid claim of harassment. Ms. Ross availed herself to the established procedures to report discrimination. As a result, Walmart terminated the employment of 3 associates. Ms. Ross never reported any other inappropriate conduct by these associates, either before or after. Regardless, Walmart took the matter seriously in an effort to ensure a workplace free of such conduct. In conclusion, I would like to add that the Commission plays a critical role in alleviating injustice in the workplace. However, this is not a matter of injustice or a matter in which the Commission should spend its valuable resources. For all these reasons, we are requesting the Commission affirm the findings of its investigator, concluding that there are no reasonable grounds to believe that Walmart or Darren Collins discriminated against Ms. Ross. Thank you.
Commissioner Douglas.
Yes, good morning.
Good morning.
Just a couple of things. That was a very comprehensive presentation. Thank you for that. The business in the report about the use of the word Guang, it's a Chinese name and so on and so forth. It's just not clear to me what action was taken in response to that, if anything.
Mm-hmm. So, and I hesitate on this a little bit because I'm basing this on my memory and don't have it in front of me. But as I recall, the recording, which the investigator had, and hopefully you have access to as well, the recording included both references to the N-word and a reference to making fun of an Asian name. So it was both the same incident, both in the same recording.
And so the 3 employees that were fired in January, that they were part of this. One of them was one of the people that was recorded.
Correct. Yes.
All right. Thank you. And then you referenced something about falling totes, and I just want to be clear about this. Is that there's an allegation about a pallet being moved and injury? This is the same incident, right? Or is it different?
It's the same incident. The incident that was described by Mr. Smits is one that I have never heard, but I assume he's explaining this one here.
Any other questions for Attorney Tierney? None. You'll have 3 minutes when we come back to you. Attorney Schmitz, you have 3 minutes and 44 seconds.
I just want to clarify a few things. Specifically, the idea that, I think it's instructive that Attorney Tierney referenced or characterized Miss McClendon explaining that Miss Ross has a disability to her manager as like an attempt to get one over on Skylar. Like, that's not what the interactive process looks like. That's not what the ADA is or the Maine Human Rights Act. It protects against individuals with disabilities. Explaining that your daughter has a disability, specifically relating to communication, as like we're trying to get one over on her supervisor who's treating her badly, is, you know, I think instructive as to the treatment that Miss Ross experienced at Walmart. You know, I'd also disagree with the Attorney Thierry's characterization of the accommodation request. Miss Ross submitted in writing, it's in the exhibit and it's in the record, to the Sedgwick, the third party administrator. To answer your question before about the palate and the injury, it's absolutely something in the record that the pallet was, or the totes were taller than Miss Ross, and that's why they fell over and injured her. So yes, we are describing the same incident when we describe that. It's the incident that resulted in her in Walmart paying $21,000 in workers' compensation for a worker who got injured on the job, doing a job that she shouldn't have been doing. I'd also like to sort of kind of tie this into, there's some confusion around cases that are related to this. I'm not going to get into the specifics of those cases other than to say this is not the only, you know, Ms. Ross went to Walmart with siblings, with family, all of whom are also people of color, all of whom also complained of race discrimination. One of those complaints involved, these were all witnessed by Ms. Ross. Again, I don't want to get into the specifics of those, but you've heard them. That in and of itself is additional evidence of a hostile work environment and adverse treatment. It's Me Too evidence is what it's referred to as. It's additional evidence that there was, you know, hostility and animus towards these workers of color that were at Walmart for a short period of time before the conditions became so intolerable, resulting in an individual's injury. You know, the sort of the last thing that I want to address is strong evidence of pretext outside of timing is inconsistencies, incoherencies, changes in the story. I've pointed out, you know, one to you already, and I think it's the most instructive one, which is that in Walmart's original position statement, they say, we had no idea she had a disability. There was never an accommodation request provided. We had no idea. How could we have known? Which of course was accepted by the report. The story now is, well, yeah, I mean, she told us about her disability, but it was to get one over on her supervisor who was treating her badly. And then, you know, yeah, they told us about a disability, but they did it the wrong way. And, you know, obviously we say that, you know, we did submit documentation to Sedgwick. That's a, you know, issue of fact here, but you know, that was also happening after Ms. Ross had already gotten injured. So that in and of itself, this changing story, that in and of itself is something that courts will look to as evidence of pretext. Thank you.
Any commissioner questions for Commissioner? Commissioner Doug.
I just want to make sure I understand this. So the exhibit that you provided, right, September 21, 2022. This is an accommodation request acknowledgement and document request, right? And says, you know, received your request. What do you need to do next? And there are all these things, right? Attorney Thierry says your client never followed it. I just want to be, because I feel like it's getting lost in the wash somewhere. What did your client do in response to this?
My client sent documentation. That's not in the record. It wasn't submitted to the commission.
Is there, I mean, can you tell me why it's not in the record?
I can't. I don't have an answer for you.
All right, thank you.
Any other commissioner questions for Attorney Schmitz?
Yeah, in order to find that Walmart's responsible for pervasive and hostile work environment, you need to find that they didn't respond to the complaints. What else, in your view, needed to be done other than firing those three workers?
I mean, there needed to be some recognition of, like, Miss Roth was treated differently. It was evidenced by the fact that she was being assigned tasks that resulted in her injury, a 17-year-old girl at that point. That sort of differential treatment, and again, I'm struggling because I'm not sure what I'm allowed to say involving other cases that you've heard, but
If those cases are closed, you may reference them. If they are still pending,
Okay.
we cannot discuss them at all.
appreciate that. You have substantiated and found reasonable grounds that her brother experienced race discrimination at the hands of one of her managers. And that was when he was called boy by one of his managers. These are workers that their family, they showed up together. They all experienced this together. Yes, that manager didn't call Miss Ross boy, but she called her brother boy. And this is all happening in the context of other, racially discriminatory comments being made, many of them ignored by both Miss Ross, because you got to get through the day, and also Walmart. So, it's being characterized like, we got to stop assigning Miss Ross, Miss McClendon, Miss Ross was like, you got to stop giving my daughter extra work. Like, that's a ridiculous thing. But she was subjected to conditions that led to her injury, conditions that are acknowledged by a manager shouldn't have existed after the injury happened. You know what I mean? And they were confronted about it. So I think, treating her like, her white coworkers, and that, giving her assignments that are fair and, won't foreseeably result in an injury are one thing. Taking her accommodation request seriously, not responding that, oh, she doesn't look like she's disabled when being told that she has a disability. There's like a host of things that Walmart could have done, other than take 3 months to fire somebody when she's already
What
on.
jobs is she assigned that are discriminatory, that others aren't
Which-
assigned also?
She's being assigned to lift pallets and lift totes, doing labor that wasn't assigned to her white coworkers, again, that led to the injury. The other thing is that, she requested help sometimes when it's in the complaint, it's in the record. She was requesting help from white coworkers. She was being ignored. Help from managers. No one additional was being assigned to help her physically lift these objects. So
Any other commissioner questions for Attorney Schmitz? Seeing none, thank you, Attorney Schmitz.
thank you.
Attorney Fury, you have 3 minutes.
Thank you. I want to just emphasize the fact that the duties that were assigned to Miss Ross were automated. So it wasn't Mr. Collins saying, Miss Ross, you go do this, white coworkers, you go do this. They came in through customer orders online. They received the orders, they would go do that. So there was nobody assigning just the heavy work, to one in particular individual. Also, when she was injured, she was pulling, and I'm not blaming her, but I am saying that she was trying to pull this cart that had totes on it and kept pulling it, and it caused it to fall. So this had nothing to do with she had, harder work, or she handled all the heavy stuff while other coworkers were not. She was never asked to work harder or differently than anybody else. I also want to mention, we brought up another matter about her brother and another coworker referring to him as boy. Walmart also took corrective action on that. And the actor there also received disciplinary action. So Walmart did not just sweep that under the rug either.
Questions for, Commissioner Douglas.
Yes, so this automated system, right,
Mhm.
with sort of doling out the work, is there evidence in the record that this automated system gave other white coworkers the same sort of duties, like pulling the totes and so on and so forth, the complainant takes issue with?
No, absolutely not. And it's nonsensical because as a manager, you're judged by your production. So it would make no sense at all to assign certain duties to, and I haven't seen Miss Ross, but she was described as being small. It would make no sense to assign just the heavy work to a smaller employee. And again, the duties do include 50 pounds or more. In the event they do have to pick up a product that is more than 50 pounds, which is pretty rare. But in the event, they are expected to ask somebody for help. And there's nothing at all on the record, any complaint of any specific individual refusing to ever help Ms. Ross.
I don't want to get too far in the weeds here, but I'm not sure you and I are using the word automated in the same way, right?
Sure.
So how are these assignments, just asking very simply, how are these assignments doled out? What is the role of some sort of, if it's in the record, what is the role of this automated system and what is the role of the manager? If it was revealed by the investigation.
It's not on the record.
Any other commissioner questions for Attorney Terry? We've heard from the parties, and next we will hear from Nooper Leva, the investigator assigned to this case. It's the Nooper show this morning, I guess, huh?
Hi, everyone. I hope you can hear me again. Good morning once again. This case, there were multiple recordings that were provided in this case. I want to address the Wong recording first. Excuse me. And in that recording, there is an employee who's appears to be making fun of Chinese individuals, and Ms. Ross does make statements. However, based on everything that was provided, it wasn't that the statements were being made at her. It just appeared that they were making these statements in general. And while they were, I'm not saying they weren't discriminatory or anything of that nature, they just weren't in this particular matter because they weren't directed to her directly, as well as yeah, sorry, those are all the notes that I had on that. The falling totes incident, the allegation was that she was being given larger pallets because of her race. There was nothing in the investigation to corroborate that. There was evidence that it's been argued by the attorney that one of her managers did say, yes, that shouldn't be happening. And that is in the record. The manager does acknowledge that she should not be having loads that were higher or taller than her. There was nothing else to indicate that it was because of her race, and that's why she was being given these taller orders. Now, as far as the disability discrimination and the reasonable accommodation, to me, the accommodation request wasn't complete because the process wasn't complete. What was requested hadn't been provided, and I wasn't given any information as to whether or not any of the documents had been provided by Ms. McClendon once Walmart had requested them. Now, I do want to talk about the discrimination with the boy incident in that case that's come up a couple of times already. I was the investigator in that case as well. And I did find that the particular individual who referred to her brother as boy was discriminatory, but Walmart itself, there was no liability on their part because they had addressed it adequately and immediately. I'm happy to take any other questions you may have.
Nooper, is it the same conclusion in this case that Walmart addressed the things that were inappropriate in the firing of those 3 people?
Yes, so the case
conclusion in the other case. Yeah.
Right. So there was no employer liability in the case. There was nothing in the record to suggest that Walmart had not done what they should have or had failed in some regard to address what was reported.
Thank you.
Any other questions for the investigator? Seeing none, thank you, Nooper. We've heard from the parties and the investigator. At this time, we are looking for a motion. There are 2 proposed findings.
Although we find that, taken together and find that there are no reasonable grounds to believe that respondent unlawfully discriminated on the basis of race or disability and nor retaliated, the complaint should be dismissed.
Second.
And seconded, is there any discussion?
I'm troubled. I'm troubled by it. I think it's a close call, and I'm really sort of relying on my investigator here in trying to sort out whether or not there's certainly inappropriate conduct and the creation of a hostile environment, and then they fire 3 people, and I'm having trouble saying that they didn't, as a matter of law, respond and attempt to deal with the problem, which is what I'd be looking for to find that there was unlawful discrimination. I think it's a close call, but I'm relying on the investigator.
Seeing none, the motion is to find no reasonable grounds on both recommended findings. If you vote yes, you are in agreement with that. Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Okay. Findings are no reasonable grounds. We appreciate everyone's participation, and we will send a letter to the parties in council confirming the results of the hearing. Damon. Go back to Damon. He is here now. So if you look, it's E230021.
Damon versus hometown development. And that recommendation again by Newbert for finding no reasonable grounds, and therefore we would hear from him.
Attorney Payson. Attorney Payson, you have 10 minutes whenever you're ready.
Hello, I apologize for the technical difficulties. My internet was cutting in and out. Just one moment. So thank you. Good morning. As you know, my name is Jessica Payson. I am an attorney at Disability Rights Maine, and I represent the complainant, Hattie Damon. As you know, we object to the investigator's preliminary report's conclusion that there were no reasonable grounds, and I thank you for giving us this opportunity to voice our concerns. This case is about an employer who used a social media platform to broadcast an offensive video to demean and ridicule a disabled employee. Ms. Damon is a person with an acquired brain injury. Ms. Damon obtained employment at Hometown Shellfish, owned by Jennifer Chase. And during the approximately 6 months of her employment, Ms. Damon experienced harassment on the basis of her disability. Respondent Chase, who was aware of Ms. Damon's disability, assigned Ms. Damon tasks that isolated her from other employees and called Ms. Damon names to humiliate her in front of her coworkers. And the severity of this harassment culminated when Respondent Chase posted a video of Ms. Damon on TikTok to over 3,000 followers. That video mocked Ms. Damon, specifically invoking her brain capacity and cognitive abilities. Ms. Damon learned of the video when she received a phone call from her sister. Ms. Damon was hurt and humiliated, yet Respondent Chase refused to take down the video because she thought it was funny. Because Respondent Chase was Ms. Damon's boss, Ms. Damon was left with no recourse to stop the harassment. Workplace tensions became intolerable and her employment ended on or around March 24th, 2023. Now, the investigators' report found that there were no reasonable grounds to believe that the workplace was sufficiently severely hostile, or perhaps that the hostility, however severe, was based on Ms. Damon's disability. However, the report omits or misstates key facts contained in the record and underexplains the relevant law that would show that the harassment Ms. Damon received was in fact severe and did target her disability. In particular, Ms. Chase's creation and publicizing of the TikTok video provides a clear example of severe harassment targeting disability. The investigator's report explains away the significance of the video on the grounds that it was not severe or did not target disability. Quoting the report, the video did not identify complainant or state that she had a disability, and the voiceover did not mimic complainant's disability-related speech. Well, the record shows otherwise. The record shows that the video does clearly identify Ms. Damon. It is a full body shot. It's framing Ms. Damon in the middle of the frame. Her face is clearly visible. There is no attempt to blur her face or any other attempt made to obscure her identity. And the record shows that the video does mimic, or rather mock, disability-related speech. It shows that while the voiceover, respondent Chase's voice, states straightforwardly that she believes some employees, quote, do not have a thought in their head. And this is said over the image of Ms. Damon at work, thus clearly implying that Ms. Damon is among the employees who have no thoughts in their head. The speaker then deliberately adopts a stilted speech, improper grammar, making use of offensive stereotypes regarding how people with mental impairments might speak. The law does consider even just this single incident sufficiently severe to potentially establish a hostile work environment claim. The Maine Supreme Judicial Court, for example, has held that the severity of harassing conduct is exacerbated when undertaken by a high-ranking employee or supervisor. The First Circuit has held that ridicule and mockery from a supervisor is sufficient. And in Arrieta Colon versus Walmart, Puerto Rico, in particular, the First Circuit held that use of a, quote, mocking tone of voice and sarcasm by a supervisor when referencing an employee's disability supported finding of a hostile work environment. So the report also does not address the legal question of how to establish a causal nexus between an employer subjecting an employee to a hostile work environment and the employer's perception of the employee as having a disability. In particular, the report did not explain that a causal nexus can be sufficiently established when a supervisor's hostile comment references an employee's disabilities and medical conditions. And this was a rule established in Fox v. General Motors by the Fourth Circuit in 2001. So we believe, given the facts of record and the more fully stated interpretation of the law, the record evidence is clear that there are reasonable grounds to believe that discrimination occurred in this case. Thank you for your consideration.
The commissioner questions for Attorney Payson. Commissioner Douglas.
Yes. Attorney Payson, good morning.
Good morning.
Yeah, I'm just looking at the report here, and I note that it says that the owner posted at least one other video of another employee while they were working. And I wonder, is that video in the record, and how do you distinguish that video from the video that you're speaking about?
Commissioner Douglas, yes. The other video, I do not believe is in the record. It is different insofar as that video does not target the individual for their disability. We really wanted to focus on this video that does, in our view, quite clearly target Ms. Damon based on the acquired brain injury.
And so the video that's the sort of the subject of your complaint here, that was posted on TikTok, as I understand it, and then your client finds out about it because somebody gives her a call, right? It was her sister, and says, you know, check this out. This is awesome. Was there any discussion of the video in the workplace?
There was discussion in the form of Ms. Damon asking respondent Chase to please take it down, and Ms. Chase refused to.
Is it in the record that any of the complainant's coworkers sort of saw the video and made comments about it? Or that respondent made other comments about the video to the extent of, sort of something along the lines of creating a hostile work environment aside from the video?
So the video was more of a sort of escalation in pattern of a hostile work environment facing Ms. Damon. So other coworkers, as well as Ms. Chase, would make comments about her voice, for example, and otherwise referencing, right, her medical disabilities, and in that case, her throat surgery. So the video per se, right, was more just sort of this culmination of Ms. Damon being isolated from other employees at work, the slurs.
All right, and then the report says that the complainant was fired, or at least that she left employ due to a disagreement about cleaning up and washing tables. Is that your understanding?
No, Commissioner Douglas. It was more, again, this culmination of the hostile work environment. The complainant in that particular occasion had a disagreement with one of her coworkers regarding, who should be doing the undesired task of cleaning the tables. This coworker had, though, been part of this ongoing sort of hostility towards Ms. Damon. So sure, the content might have been directly about the, who cleans the tables, but it was about this coworker sort of continuing to be hostile towards and single Ms. Damon out.
Thank you.
Any further, Commissioner? Yes, Commissioner.
Yes, the investigator says that with regards to the video, the record shows that, and complainant confirmed, that video does not contain any content that could be considered disability discrimination. And how do you react to that? You say the video does show disability discrimination?
Yes, Commissioner. I honestly think that that's a misstatement of facts. I think it's clear that the video shows disability-based discrimination. The content, the saying there are no thoughts in her head, the sort of stilted speech and the cadence, I think it's quite clearly taking on a mocking tone about someone who has a mental impairment.
Okay.
Any further Commissioner questions for Attorney Pace? Seeing none, Attorney Payson, you'll have about 4.5 minutes when we come back to you. Ms. Chase, are you here for both respondents?
I didn't hear what you said.
I said, are you here for Hometown Shellfish and for your? Okay,
Yeah.
All right, you have 10 minutes. Whenever you're ready, you may begin.
I don't really have anything to add because I kind of sent everything to the investigator. Just the fact that I did send, like, she asked to make videos with me, so there should be in there somewhere a message from on Facebook that has asked. She also commented on the video that I can't remember if she said that's me or whatever, but she liked the video. And when they talk about her being isolated, my shop is a one-room shop, so all the tables are like literally the two tables are right next to each other. So I'm not sure where she really gets the isolation part. The second video that you guys asked about, one of my other employees she's like, yeah, let's do it. And so it definitely wasn't about her disability. I made the video, I showed her. There actually was no music going on in her things because she had stopped it. So she had reenact what she was doing because it just kind of went with it. It wasn't meant to be harmful or anything like that. And as soon as I got the paperwork, of course, I took it right down. She's never asked me to take it down. I guess unless, and like I said, I sent the investigator the text messages, and as a hostile environment, like I sent the investigator messages that says like, you're a great boss, you know, and like, I'm not sure, I'm not sure what she's trying to do here, but they have everything that I sent, so I don't really have anything else to say.
Commissioner O'Brien.
Thank you. Why did you do the video? What was,
So sometimes I have quite a few actually of my employees on there. It was just something fun that we like to do. We have some political ones on there. It was just, you know, our employees and I, we like to just fool around. Like I said, it was not intent of being harmful or anything like that. But just, we were just having fun. You know, if you could have seen, you know, there's a ton of them on there with my employees. And everybody's always asked, if you want to be in a video, if you don't, that's cool. It was just something that we were just doing, and I guess I really didn't have a reason. We were just having fun with it.
do you disagree that it kind of mimicked her cadence and her speech? Do you disagree with that?
I do, because it wasn't to mock her disability. And she's the one that said she liked it on the post. And I think the investigator actually brought that up in one of the things that she talked about.
Thanks.
Ms. Chase, do I understand that you just said that she participated in making the video? You asked her if she wanted to be in a video?
Yes.
And why did you make it?
We make them over at the shop just to have fun. It wasn't, like I said, it wasn't to be disrespectful or any of that.
And who asked you to take it down?
Nobody asked me to take it down. I took it down after I got paperwork from the commission.
She never complained about it?
She never asked me to take it down or anything.
I mean, there must have been a long time frame between making the video and getting the complaint from the commission.
There
Right?
was, and that's why I was surprised when it was in the complaint, because like I said, she liked it. She never asked me to take it down. And I have the text messages that I sent into the state that said that she wanted to make the videos with me. So I don't have, you know, there wasn't anything there.
She said she wanted to make the videos with you?
Yep. Somewhere I sent a text message into the state that showed our conversation.
I'm showing my incredulity, lack of understanding about social media, obviously. Thank you.
Further question for the investigator. Any further questions for Ms. Chase? Okay, seeing none, you'll have about 8 minutes left when we come back to you. Attorney Payson, you have about 4.5 minutes if there's anything you'd like to add.
I would like to add that there is nothing in the record that says that Ms. Damon liked the video, and certainly that wasn't part of the investigator's report. To the contrary, we have, you know, the complaint, the final argument submitted by Ms. Damon, all saying again and again that she asked Ms. Chase to take the video down, and she refused for very similar reasons she's saying right now. She just thought it was funny. Right, I would just like to point out that there is no record evidence showing that Ms. Damon was okay with this.
Any further commissioner questions for Attorney Payson? Yes, Commissioner Douglas.
Yeah, Attorney Payson. So I just want to be crystal clear about all of this, right? Because So Jem says that there's number one, a text message saying that your client wanted to be in a video, right? That she actually liked the video. I think you just stressed that. That she never asked.
Cooking videos over time.
Ms. Damon,
All right,
Ms. Damon, we're gonna let your attorney make the presentation, please.
And
thank you.
I mean, can you address the text message? There's no such text message in the record from your perspective, I'm guessing.
I don't see one.
Okay. Was there, and you understand that we don't see every piece of evidence in the case, right? So one of the things that we don't have is the post, right? The TikTok post. And I'm wondering, was that post part of the record?
Yes, Commissioner. There was a thumb drive submitted along with the initial complaint.
What I hear you saying is that you could see who liked the post and your client was not one of these people.
Oh, I see. No, we submitted the video itself.
Oh, I see. Okay. I'm asking about the TikTok post, right? Because there's a video posted on TikTok that presumably people can like the video.
Right.
So what I'm, there's an allegation here that your client liked the video on TikTok. If I'm understanding this correctly. I see Jen nodding. And I'm wondering what your perspective is on that. Is there evidence in the record to show that your client did or did not like this video?
Oh, I'm disputing. She did not say, I like this video. I believe what Ms. Chase is referring to is a smiley face posted on the video, which Ms. Damon explains as sort of cheeky, like, you thought I wouldn't find this, but I did, sort of gesture. In any case, it didn't seem to play a role in the investigator's report, which is why I did not address it in the objection.
Then you allege that your client asked for the video to be taken down, and I believe you said that was at the workplace. Do you have a sense as to when that was? Was it immediately after she was notified of the video?
I believe it was immediately afterwards.
Thank you.
Yes, do you dispute what was said that the video was recreated? I think I heard that it was recreated, so obviously she was a willing participant. What do you say about that?
I'm sorry, are you saying that Ms. Damon reposted the video or something like that?
No, recreated it in that it was videoed a couple times. That Miss Damon that staged. Yes, that it was a staged video. I think that that was just stated earlier. You didn't catch that.
Oh, no, yeah, we absolutely dispute that Ms. Damon consented in any way to this. The video itself shows her sort of, not even looking at the camera, has headphones on. There's no indication of consent in any of the records.
Okay, thank you.
Any further commissioner questions for Attorney Payson? None. We'll move back to Ms. Chase. Ms. Chase, you have about 8 minutes if there's anything you'd like to add.
I don't really have anything to say. Like I said, everything was submitted. I said, I sent over the messages that said she wanted to make videos with me. So we made videos, we reenacted it. I know she says it didn't. She never asked me to take it down. I took it down of my own free will after I got the papers from the commissioner's office. Charmaine's is still up. And that's the other one she's talking about. I just don't really have anything to say. I'm just not really sure here.
Any other commissioner questions for Ms. Chase? Seeing none, we thank you both. We've heard from the parties, and next we'll hear from Investigator Leva.
Hi, good morning once again. Um, so the case here focused a lot on that video and that social media post. I watched that post over and over and over to figure out whether or not I thought it was discriminatory. I spoke with Miss Miss Damon at the IRC based on the way that she was talking to me and the way that I saw the post. It did not mimic her speech cadence, and while it did show like her picture, it didn't identify who this employee was. It provided no other identifying factors of her. And based on everything that I had received in the way the answers that Ms. Damon had provided to me in the IRC, it didn't seem like that video was intended or mocking of Ms. Damon herself or her disability at all. So based on that, I didn't think that that created a hostile enough environment. As far as slurs and statements, I don't have anything in the record and I don't see anything in my notes about that. I'm sorry.
No,
Oh,
you're fine.
okay. Sorry. Um, about anything of that nature that appeared to be toxic or that Miss Damon that it affected her work or anything of that nature. And the final thing I have is that she was kept isolated from other individuals. I did get a layout of the place from Miss Chase, and the way that it was laid out while she was at a different table, they were all in the same space. The tables were close enough that you could speak to one another. It didn't appear that she was isolated in any manner to me. And I didn't see anything in the record showing that Miss Damon agreed or wanted to take videos, but there was both parties disagreed on whether or not there was permission to take the videos. And in the end, I decided that whether or not there was permission to take the video was irrelevant to whether or not the video would have been discriminatory. Any questions?
Commissioner, questions for Commissioner Douglas?
Yes, the new per hour continues. So there's been some commentary, and I know you said it's irrelevant, but I'm curious nonetheless about a text message where the complainant said she wanted to take place in these videos. I'm just wondering, is there any such communication in the record?
Let me look over that. I don't recall seeing that. I have her record pulled up right now, so I'm checking as we speak. I don't see anything of that in the record.
Well, I appreciate you checking. And then this business about the video on TikTok, right? There's been some commentary about whether or not the complainant actually liked the video. There's something about a smiley face posted, and so we can dispute what that was, but is there any evidence in the record about that?
Yes, there was evidence in the record about that. There's a screenshot provided of the comments made in that video. And Ms. Damon did say, "You made this video perfect, LMAO." I asked her during the IRC why she made that comment. And she said that she doesn't know why she made that comment. My notes say does not know why comment was made at all.
And this business about whether or not the complainant asked her employer to take the video down. What did your investigation reveal about that?
Again, that was disputed and there was no evidence to show that a conversation requesting it be taken down occurred or that any text messages were shared showing that the video be taken down.
Know whether it's accurate that the video stayed up on TikTok until they responded, got word of complainant's action with the Maine Human Rights Commission?
I don't know that, but because Ms. Chase in this case said that she only took it down then, I assumed that it had been up this entire time and that whether Ms. Chase or Ms. Damon asked for it to be taken down or not, it hadn't been in that time period.
But I'm just curious, you said that you didn't get the sense that the video was posted, for some sort of, it wasn't motivated by some sort of discriminatory animus or anything like that. And I'm just wondering, what if any sense did you get as to why this video was posted based on your investigation?
So based on what I was seeing in the video, it seemed like it was a soundbite. It seemed like it was some sort of trend that was going around where people copy each other's videos and make their own kind of version of the video. This seemed to be that same thing. It was Ms. Chase making her own version with a soundbite that was already out there.
Your report references at least one other video of an employee while they were working. What can you tell us about that video?
I don't know too much about that other video. The notes that I do have is that a video was posted with similar language earlier that year, and that I have no information on whether that or not that individual was disabled. But to the best of my knowledge and based on the questions I asked, that person was not disabled.
Fair to say that information came from the respondent?
That information, yes, that is fair to say.
Okay, but you never saw the video, true?
No. Yeah.
All right, thank you.
Any other questions for Investigator Lip? Okay, thank you, Duper. We've heard from the parties and the investigator. At this time, we are looking for a motion. One proposed finding.
I will move there are no reasonable grounds to believe that hometown shellfish Jennifer Chase discriminated against Hattie Damon on the basis of disability and that the complaint should be dismissed. Second.
Moved and seconded. Any discussion?
Issue that I'm having. It's another one of those restaurant cases where I'm not sure how I'm gonna go until the waitress comes over, but the voiceover said, I mean, this woman has a brain injury, as I understand it, right? And the voiceover says, do you have that coworker you look at and just think there's not a thought in their head, and you ask them to do anything and they're like, we think no, and I'm like, yep, that sounds about right. I mean, in the first place, and I think this needs to be said, it's extremely unwise for an employer to be posting a video like this about their employee with a brain injury. Let's get that out there first of all. But that said, I mean, the complainant finds out about it. There's an allegation that she confronts respondent at work. It's disputed, I understand, but this is what happens at trial. Some people present this set of facts and then the side gets to rebut. And, I don't know. I'm really on the fence about this one. I think that's probably enough to create a hostile work environment. And I think it's an interesting case.
I don't disagree, Tom. I mean, I think it's close. I think the video's stupid, but I'm not sure if it reflects discriminatory animals. I'm not sure. I'm not comfortable calling it that as a finding.
But I think a jury could find. But that's the problem. I think a jury could find that there's discriminatory animus. If they learn that this woman has brain injury and then they see this video, which is posted for no Yes, okay, there's like a trend about mimicking other videos, but I think you could find a million other people on Earth rather than your employee who posts this video about. So, I don't understand why you would do that. So I think a jury could believe it.
Yeah.
I don't know.
Because I was persuaded by the finding that complainant this is from our investigator, that the video did not identify her, did not mimic her speech, affections or cadence, and affected by her disability. I'm relying on my investigator, as you said in the last
There's
case.
a full video of her. I mean, she doesn't need to be identified.
Right.
She's there in the video, right? I mean, I'm introducing this to trial. I don't need to have somebody to come and confirm. The jury can see that it's this woman. So, of course, she didn't like the video.
Well,
She did a little smiley face, and that's an issue as well.
The video displays her and it's her, but it doesn't identify her saying, look at this stupid employee and how she doesn't have a brain in her head.
But her coworkers know it's her. That's the analysis.
What?
Her coworkers, people she worked with, knows it's her. She's fine.
Any further discussion?
I've got 30 or 40 more comments, Kit.
I mean, listen, we can stay here all day, but I have not ordered lunch for you all, so I
Okay.
imagine at some point you're gonna wanna.
Hit me where it hurts, buddy.
I have been doing this for a little while. All right, any further discussion? Seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
No,
Commissioner Walker,
yes.
Commissioner Douglas.
No.
Okay, so again, it is a tied vote, which means we will revert to the commissioner, to the investigator's finding. No reasonable grounds case. So the findings are no reasonable grounds. We appreciate everyone's participation. The Commission will send a letter to the parties and the council confirming the results of the hearing. You all can take this up with Meg when she's back in March.
yeah.
Can we take just a very brief?
Okay.
Preliminary? I want to
And we're hearing Scott versus Albertson Company E230254. And that is a recommendation of no reasonable grounds on age discrimination, but reasonable, recommend that we find that there's reasonable grounds in regards to disability. So that's the primary finding. So we will, since the reasonable grounds recommendation, we will hear from respondent.
I need to recuse myself.
Okay. Attorney Reed, you have 10 minutes. Do you want to save any of your time?
Yes, I won't take nearly that long. So let's say 5 minutes reserved, but I'll probably be done in 2 or 3 minutes.
Whenever you're ready, go ahead.
All right. Thank you. As stated, my name is Kevin Reed. I work for Albertsons Companies, Inc., the parent company of Shaw's. We oversee all legal matters for them. So that's just a little bit of background. This case here is fairly simple. It comes down to whether or not limitations could be accommodated. And it's quite simple. Miss Scott was a fresh cut clerk who could not cut fresh produce. You know, this is a special position. It's a part-time position in all 148 of our stores that is separate and distinct from a regular produce clerk. These clerks are responsible for basically cutting up fresh fruit and vegetables to be sold in the pre-made containers you see stacked at the grocery store. And there were 2 main restrictions that Miss Scott had that we could not accommodate. The first being her weight limitations. This position requires up to 60 pounds of pushing and lifting and pulling on a constant basis. It's a daily part of the job. And then also cutting up quite a bit of fresh fruit and vegetables. The investigator here kind of disregarded the evidence. You know, we submitted statements from a 39 and 37-year employee that supervised Miss Scott, explaining that she couldn't do her job, explaining that they had to hand things over to other people because she was incapable, and they just kind of get tossed aside. I mean, we submitted a statement saying 20 melons are cut each day because we were asked how many watermelons are cut. But because the magic word water wasn't included in melon, it was disregarded. And the fact that she couldn't cut 20 watermelons a day was poo-pooed. Similar to the cart, it weighs 60 pounds when loaded, but the response was, well, she can carry the produce in and out from the floor. But that means she has to pick up a watermelon, carry it from the produce section or the back room into the deli, chop it up, package it into small containers, and then carry those small containers back out and stack them. You know, there is just the practical aspects of the job require a fresh cut produce clerk to cut fresh produce. And, you know, we submitted the evidence, and the dispute seems to be on what her position even was. Was she a produce clerk? Was she a cut produce clerk? We submitted the employment history report showing she had indeed moved to the fresh cut clerk position at the time of the incident. And so the evidence really doesn't support this finding that there's reasonable grounds to believe that there is discrimination. Again, a fresh cut produce clerk must cut fresh produce. It's as simple as that. That's why we have 148 stores with this specialized position. And to say it's not an essential function kind of eliminates the need for the position, and it begs the question, then, you know, why did we create it in the first place if it's not essential? So I think it's just a simple dispute here about what the facts really show, and I'll reserve my time.
Okay. Any commissioner questions for Attorney Reed? Okay. Seeing none, Attorney Reed, you'll have 7 minutes when we come back to you. Attorney Young.
Here.
You don't serve any of your time.
2 minutes. Good morning, Mr. Chairman David, and members of the commission. My name is Jeffrey Gale Young. I'm with Solidarity Law, and I am here this morning representing Desiree Scott, who is with me. She just stood there. The investigator properly concluded that there are reasonable grounds that the employer, Albertsons Companies, doing business as Shaw's, I'm going to refer to them as Shaw's, that's what they are here, discriminated against my client Desiree Scott on the basis of disability when it reduced her hours and placed her on an unrequested leave of absence. First of all, there's no dispute here that Ms. Scott is disabled within the meeting. of the ADA and MHRA. Ms. Scott worked at Shaw's for 15 years. The function of cutting watermelons and avocados actually did not exist when she was hired. It was added, became a function after she was hired. So the central issue in this case is whether cutting watermelons and avocados was an essential function of her job. Shaw's claims that it put her out of work because she could not do so. However, we claim that it was not an essential function of the job and that in fact, Ms. Shaw was not, or Ms. Scott, excuse me, was not a fresh cut clerk, but she was a produce clerk. That was what was indicated, perhaps most importantly, on all the department schedules. It was indicated in the department schedules are in the record as Exhibit 8. It was indicated in the employee portal, which is Exhibit 8, the other one, the schedules are Exhibit 10, I'm sorry, and Shaw's own punch data. Significantly, on the schedules at the store, the Scarborough store where Ms. Scott worked, there are other individuals, but not Ms. Scott, listed as a fresh cut clerk. In addition to that, Ms. Scott adduced evidence, not just from herself, but other witnesses, that's just in the record from JH, that whatever her schedule was, or whatever her title rather was, that she was not expected to cut watermelons and avocados. Rather, her job was, and she was able to do this throughout, was to stock the salad bar and cut vegetables. And as the investigator found at page 4 of her report, when watermelons and avocados needed to be cut, there were multiple employees in the department, 9 workers and 2 managers, or 11 individuals altogether, who were capable of cutting the watermelon and the avocados. The record in the evidence is not that there were 20 watermelons per day. The evidence was inconclusive as to how many watermelons actually had to be cut. Ms. Scott was able to, if she had to, although she didn't do it, cut the other melons. But most importantly, as the schedules reflect, there were 2 employees who were specifically scheduled to cut watermelon and avocados. SP was scheduled to work 5 days a week at 7 a.m. in the morning, come in at 7 a.m. to cut watermelons and avocados. On days when SP was off, there was another employee, RM, who was scheduled to report to work even earlier at 5 a.m. Ms. Scott herself, if you look at the schedules, was never scheduled to report to work until 9 a.m. And that's significant because getting the salad bar stocked with the avocados and the watermelons, you have to obviously cut them and prepare them first. And that's what those other 2 employees were doing when they came into work. Ms. Scott, once she came into work at 9 a.m., was then stocking the salad bar. What really appears to have happened here is that Shaw's decided to reduce Ms. Scott's hours and put her out of work altogether, not because she couldn't perform her job. She was stocking the salad bar, but rather because a workers' comp adjuster said that Shaw's no longer had to offer her work. That's at the report at page 4. So whatever might be the case under workers' comp law, you have to look at the ADA and the MHRA. And here Ms. Shaw was able to, or Ms. Scott rather, was able to perform the essential functions of her job as the investigator found. I'd be happy to answer any questions. Thank you.
Questions for Attorney Young?
I'm not sure I understand what you just said about the workers' comp.
Well,
Saying,
I'm sorry, go ahead.
go ahead. No, tell me what.
She was receiving some workers' compensation benefits.
Okay.
And at some point, the worker, and she was working there, at some point, workers' comp, and I think this isn't the most important point in the case, but at some point, workers' comp adjuster told Shaw's that they didn't have to keep having her work. in her position, that she'd somehow reached a maximum, I don't totally understand it either, a maximum number of hours during the year, and so that Shaw's no longer had to keep using her. And Shaw's then reduced her hours and put her out, and then ultimately put her out of work. But I think the key thing is here,
And you're saying they did that with discriminatory animus based on her disability?
yes, I'm saying that regardless of whatever the workers' comp law might have to
Right.
say, that they still have to comply separately with the ADA and the MHRA. And that required, she was able to do the essential functions of her job, which I know there's a dispute about this, but the record shows that what she was doing throughout her entire employment was not cutting watermelons or avocados, but was stocking the salad bar.
And the duration of that employment is 15 years?
15 years.
Okay. And I understand that you're saying no matter what the listings are of whether it's a cutting clerk or a produce clerk or whatever, that in those 15 years, she was not doing that
You have to
job.
look at what she was doing, correct, and that's what she was doing.
Okay.
The recommendation, there's two issues. One, but there's a recommendation, there's no reasonable grounds that it was discrimination based on age. Are you?
We're not saying.
Okay, thank you.
Any other questions for Attorney Young? Seeing none, Attorney Young, you'll have about 5 minutes when we come back to you. Attorney Reed, you have 7 minutes.
Okay, thank you. To quickly address the job title and whether or not she was a fresh cut clerk, we provided in the initial submission an employment history report that shows on December 2nd, 2021, her job was reclassified to the new position. That system, that spreadsheet I provided is a direct export from our HR system. Any associate who you can see their hire date, job transfer date, pay increase date, it's system generated. We provide that and it shows on 12/2/21, her title changed. So that's, I think, a simple one. We also have 2 written statements from her supervisors, one with 37 years experience, one with 39 years experience, who call her a fresh cut clerk and lay out her duties. So I think on that, we have a factual dispute we won't agree on regardless, so I won't belabor the point. Regarding the workers' comp question, workers' comp under the statutory scheme has a concept we used to call light duty. Now it's called temporary alternative work, but it's the same concept. By returning somebody to work on light duty, you could reduce your workers' comp premiums. It's an incentive to lower your insurance rate and at least keep people working a little bit. Under workers' comp, you can remove essential job functions to put them in light duty, but it is limited by the workers' comp plan to a certain amount of time. You can't stay on light duty forever because then it's no longer light duty, it's just duty. She had reached her maximum statutory requirement for workers' comp, and therefore that part of her employment was no longer available. When workers' comp coverage ends, you must move into just the standard ADA, which does not call for essential job functions to be removed. So I think it still comes down to the question of essential job functions here, the watermelon and the pushing carts, which factually the record is what it is. But to use workers' comp statutory scheme, which is fundamentally different than the ADA when it comes to job duties, is, I think, misplaced here. And trying to say, they ended it in for retaliatory reasons. No, we ended it pursuant to the statutory entitlements of a workers' comp program. You don't get to stay on it forever. So I think that's just the real mistake that was made here in this report is, not really understanding the interplay of how those two systems work together. So that's all I have on the issues raised by Attorney Young.
Commissioner, yes, Commissioner.
Attorney Reed, you just said in rebuttal that it's clear that she was a fresh cut clerk because of some paperwork that you cited says she's a fresh cut clerk. isn't 15 years of history relevant to deciding what she was? What job she did?
Well, no, because she moved jobs. She was a produce clerk. We created the fresh cut produce clerk position, and she was moved over to that because it has separate job duties. You've seen over the last couple of years.
You never had a fresh cut clerk before?
No, it's a newly created position because we started selling more of those. You know, you see in the stores like the pre-cut watermelon, the grapes mixed in with pineapple and strawberries. People were buying pre-cut fruit much more often, and it's quite a big money maker for us. So the fresh cut clerk position was created to serve that need. So when you walk into your Shaw's or Star Market or any of the other stores, Albertsons owns, you'll see in the produce section a big rack of pre-prepared fruit. And
She
sometimes
couldn't do that because of her disability.
correct, but that was her job, was to do that.
Okay.
Go ahead. I didn't mean to cut you off, sir. Please.
No, you didn't.
Any other commissioner questions for Attorney Reed? Okay, seeing none, Attorney Young, you have 5 minutes.
Thank you. Bottom line is this, whatever her job title was, she never cut watermelons or avocados. They may have changed her title in 2021, but she still kept doing what she always had been. Was cutting fresh vegetables and then stocking the salad bar. There were other people who were designated to do the cutting of the watermelons. And so in our papers, we indicated that by law, if you have multiple people who are capable of performing a function, then it's not necessarily an essential function, but even if it is, and we have multiple people who can do that, you let other people do it. They had other people assigned to do that work. That's so, and as
how long does she continue to only be do the produce work that she'd always been doing? And why does it end? Because of the workers' comp?
Mr. Reed explained what the workers' comp situation may have been, but her job continues to be what it's always been.
Until when? How does she get
forever? Unless they start requiring her, and they don't, because there were other people who were assigned to do that.
Do they discharge her?
Yes.
Yeah.
Well, in effect, they did. Let's put it that way. They put her out of work. They never recalled her. This is in the record. There was another store opening. They never offered her an opportunity to go to the other store.
How long after this supposed change of job title?
She kept doing the same job. The supposed change in job title was in 2021, and she was, what year were you left on?
June, August 29th.
So she kept doing the same job.
I didn't hear it. 23?
August 2022, she said. So she kept doing the same job for another year.
For another year is the answer. Thank you.
Other commissioner questions for Attorney Young? Okay, seeing none, thank you both. We will next hear from Angela Morse, the investigator assigned to this case.
Hello, my name is Angela Morse. I was the investigator assigned to this case. There's just a couple things I want to point out. One would be in respondent's final submission, there was a punch. There was an Excel spreadsheet with punch data from 2022, and the job title assigned to Ms. Scott on this Excel spreadsheet that was, again, provided by the respondent as the final submission lists the job title as produce fresh clerk. I asked very specifically to get some, so, you know, the two tasks that we're looking at that are an issue is guacamole, and not even all guacamole, because not guacamole made from overripe avocados, but the avocado, the product that comes in bags and is the blocks of the avocado pulp, and also cutting watermelons. I asked for specific numbers about how many watermelons are cut each day, and I never received that. I got numbers regarding how many melons could be cut in a certain day, but that wasn't based on this specific store. where the complainant worked. I've also got information and numbers regarding honeydew, cantaloupes, watermelons, berries, and pineapples. And complainant only had difficulty with one of those fruits, which is the watermelon. I did not see, based on the evidence here, that the cutting of the watermelons and the preparing of the guacamole from the frozen product was an essential function of the job. And certainly it's not something she was doing during her long work career there. So based on that, I definitely think that there's sufficient evidence that complainant could prevail in a civil action, and I'm certainly willing to answer questions.
Any commissioner questions for Investigator Morris? Seeing none, thank you, Angela. We've heard from the parties and the investigator. At this time, we are looking for a motion. Commissioner Bryant.
I would take them together, that there are no reasonable grounds to believe that Albertson companies discriminated against Desiree Scott on basis of age, and that there are reasonable grounds to believe that Albertson companies discriminated against Desiree Scott on the basis of disability, and conciliation of that claim should be attempted.
Second.
And seconded. Any discussion? Seeing none, the motion is to find no reasonable grounds as to age and reasonable grounds as to disability. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Okay. So the findings are split, no reasonable grounds and reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and the council confirming the results of the hearing.
This case for hearing this morning is housing case 824-0350 ABC Barnett versus Ellsworth and Mount Desert Island Housing et al. And the recommendation is for a finding of no reasonable grounds on both counts, and therefore we will hear from complainant.
Barnhart?
Hi, I'm Lucy Barnhart and I am the complainant. I declare under the penalty of perjury, the foregoing is true and correct. 28 U.S. 1746. For the past 6 months, I continue to fight for my rights under the Maine Human Rights Act to accept my rights. Mount Desert Island Housing Authority, Jennifer Richardson, Bar Harbor Housing Authority are in violation of 5 MRSA 40582 unlawful housing harassment, MHRA 4592 unlawful public accommodations 1, 4, 5, and 6 for denial, participation, integration, and association. The U.S. Supreme Court determined there is a right to a new trial when suppressed evidence raises a reasonable probability of a different result. Tiles versus Whitley, 514 U.S. 419, 1995. I am entitled to a new investigator, a report, and a hearing because investigator Carrie McCarter deframed me, breached my private health information, suppressed favorable evidence, disregarded the Maine rules of evidence and the Maine Human Rights Commission's own regulations. The investigator violated my right to private health information by sharing with each respondent and counsel without redaction. After my written request not to share publicly, I submitted a brief notification to the U.S. Department of Health and Human Services Office of Civil Rights. The investigator suppressed evidence in the affidavits, including my complaint to Jennifer Richardson titled Rhodic Lorraine, handicapped, lack of parking access. Jennifer Richardson and Weston Bremen's complaint request states resident access to unnumbered parking spaces. Reasonable accommodation requests include photos emailed to Investigator McCarter on November 7th, who forwarded two respondents' emails to Jennifer Richardson on August 10th, August 13th, September 24th, September 25th, and October 13th. Maine Human Rights Commission regulation prima facie case has at least the appearance of a disparate treatment. However, the investigator concluded complainant failed to establish a prima facie case. Complainant did not show she requested a particular accommodation that respondent did not grant. Additionally, the investigator suppressed all documentation of harassment, including my conversation with the Bar Harbor Police Department, Liam Harrington, about my concern about using handicap parking after the removal of a handicap tenant from the handicap space. The addendum omitted every reference I made at the IRC in regards to the effect of harassment and discrimination. I'll summarize. I reported harassment to the Bar Harbor Police Department, the deterioration of my health to need new prescription medication and a new specialist, the loss of visitation of my grandchild due to family concerns about unfounded tenant complaints, strained family relationships due to worry about my lease being terminated to the vague other reasons clause. I avoid the lobby whenever possible, and I won't even get the mail if people are present, and I live in constant fear at my home. The investigator concluded complainant did not establish that she was subjected to severe and pervasive harassment, which created a hostile housing environment. These complaints fail and will not be further analyzed here. The investigator, respondent, and HUD disregard Maine Human Rights Act 45924, which requires respondent to provide access. Instead, they shift the burden of proof to the aggrieved party to prove additional reasonable accommodation needed for existing handicap services. The report states both respondent and HUD suggest complainant request to alternate parking space. Complainant did not do this, and she has still not requested a reasonable accommodation related to parking. Your regulation says obligation for reasonable accommodation states a separate service is not an acceptable substitute for making a conveyance accessible. 94-348, Chapter 5, D2. The investigator wrote, even if complainant did raise the issue of the outdoor trash receptacle at the meeting, this still did not constitute a reasonable accommodation request. Nevertheless, the respondents reached out and they are on a waiting list. Weston Bremen's letter of response to complaint acknowledged the complainant did make the request for an accessible dumpster. The investigator denies the request and reframes the respondent's response as a goodwill action. Maine law finds it inherently defamatory when false statements are repeated to a third party. It's known as defamation per se. The investigator wrote, complainant intended to make the request. However, complainant never actually made the request. There is no evidence in the record that complainant left a voicemail. At the IRC, the operations director credibly asserted, the non-disclosure agreement prevents me from calling witnesses to the calls to the operations director and the situations in the affidavit. The IRC statements are unsworn statements. My submitted affidavits were sworn under oath in front of a notary of the public who documented them. Main rule of evidence, Rule 405, allows specific instances of a person's conduct as a method of proving character. The letter of response to complaint lists Jennifer Richardson and Ally Bodge, the operations director, as
Ms. Barnhart, please don't use the names of these individuals if they're not named respondents.
They
You can
are.
use their job, they're not.
They
You can
are.
use their job titles.
Oh, I'm
please.
sorry.
You
Sorry.
may use their job titles, but you may not use their names.
Okay, sorry. I'm sorry. The operations director I lost my place. Hold on a second. Hold on. I lost my place. Well, anyway, these unnamed individuals are, in possession of let me just go on. So Mount Desert Island Ellsworth housing staff, they have unlawful possession of the wheelchair and the request for aid. They did not answer my request for aids for help with parking, food and cleaning services, and are documented in the affidavits. The Maine Human Rights Commission is charged to prevent discrimination. My expectation was that the commission would follow Maine Human Rights Act 4592, 5, and 6, and 5 MRSA 4582. However, my experience has been that the Maine Human Rights Committee reasonably used the act of reasonable accommodation to deny my rights. The inspector defamed me, breached my private health information, suppressed favorable evidence, disregarded the Maine rules of evidence, Maine Human Rights Commission's regulations in the process. Kyles versus Whitley shows I have the right to a new hearing, and I request to introduce photos, current photos, and show non-compliance to the handicap access at my home. And I hope the commission will address unlawful conduct. Questions?
Commissioner questions for Ms. Barnhart? Seeing none, thank you. You'll have about a minute and 10 seconds left. Thank you. Attorney Bethany?
Yes. Hello.
Great.
Good morning, everyone. I'm Joe Bethany. I am the attorney for the Ellsworth and MDI housing authorities, the Bar Harbor Housing Authority, and Jennifer Richardson, the respondents. With me are Weston Graham, who's the executive director of the housing authorities, and to my right or left is respondent Jennifer Richardson. I will be exceedingly brief as we approach 12 o'clock. First, I would like to thank the investigator in this matter. I thought that she had a tough job here wading through the submissions, but she handled the matter with what I thought was grace and dignity and asked appropriate questions during the course of the Issues and Resolutions Conference and produced a solid report.
Attorney Bethany?
Yes.
Can I just pause you there for a moment? The investigator uses they them pronouns.
Oh, I apologize. I apologize. So in terms of the particular issues in the report, really there are, I suppose, two issues that Ms. Barnhart raised in her rebuttal. The first of which is with regard to a parking spot. That issue is spelled out in the report. Basically, she made a complaint in August of 2024 to Ms. Richardson and Mr. Graham regarding the use of the handicap spots at her development. She alleged that, quote, only the chosen residents are allowed to use those spots. But notably, she did not mention her disability or make a reasonable accommodation request with regard to those handicap spots or the use of those spots. Prior to filing this complaint, Ms. Barnhart filed a complaint with HUD in Boston regarding those handicap spots, and HUD appropriately found that they are available on a first come, first served basis. So they are available to residents, and otherwise there's no evidence in the record here to the contrary. The only other real issue is in regards to the trash receptacle, and the report found that no reasonable accommodation request was made with regard to that because Ms. Barnhart did not link her request for an accessible trash receptacle to her own disability. She was making that request on behalf of a third party. So again, the report is well done, and I would encourage the commission to adopt the conclusion of the report and find that there were no reasonable grounds to believe that discrimination occurred. And I'll answer any questions from the commission if they have any.
Apologize to Ms. Barnhart because you're correct. Ms. Richardson absolutely is a named party. The other person you named was not. So you may use Ms. Barnhart's name. Very sorry about that. Richard, yeah. It's lunchtime. I'm sorry. You may use Ms. Richardson's name. Please don't use anybody else. Okay, commissioner questions for Attorney Bethany. Being none, you'll have about 6 minutes and 50 seconds when we come back to you. Ms. Barnhart, you have 1 minute and 10 seconds. If there's anything you'd like to add, you don't have to. Okay. Attorney Bethany, anything further you'd like to add?
No, thank you.
Okay. We have heard from the parties, and next we'll hear from Carrie McCarter, the investigator assigned to this case.
Hi, Carrie McCarter. I don't think I have anything that needs to be clarified, but I'm happy to answer any questions.
It's like we've got quite a file there.
Commissioner questions for Investigator McCarter. Okay, thanks, Carrie. We've heard from the parties and the investigator for a motion.
I'll move, taken together, I move we find that there are no reasonable grounds to believe that respondents discriminated on the basis of disability, nor retaliated, and the complaint should be dismissed.
Second.
Okay. Moved and seconded. Any discussion?
The report is extremely comprehensive and deals with each issue, and I don't, the lack of questions doesn't mean that I didn't read it. It just means that it seems straightforward.
Full part of the second, all of those comments.
Any further discussion? Being none, the motion is to find no reasonable grounds on both recommended findings. If you were in agreement, you would vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
The findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and the council confirming the results of the hearing. And that concludes the hearing agenda.
Now. Pursuant to one RSA 4056E, I move we go into an executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Moved and seconded. Is there any discussion? Okay, seeing none, if you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Okay. We will take a little break while we do this. Okay, so I need a motion to litigate H24-0193-A McAllister versus Sapiel, and not to litigate E22-0304-A Carter versus Christmas Tree Shop. If you vote yes, you are in agreement. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
And I need a motion to, are we accepting the agreements in both of these, or are we waiting for something else? For public interest remedies or for policy review?
No, we are moving to accept the agreements and authorize me to sign.
Okay, so moving to authorize the agreements in H19-0428 Bartos Loggins versus Twin Cities and Olga Dultiser, and H22-0253 Deshane versus the Auburn Housing Authority and Daniel Jordan, and to let Commission Council sign.
So moved.
Yes, you are in agreement. Commissioner David?
Yes.
Commissioner O'Brien? Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Okay. I think that ends the meeting. Everybody go have some food.